Well, hey, everybody. Is it good to be home or is it good to be home? Oh my gosh. Welcome back. Welcome back to my home studio, my fish. Oh, it's just been wonderful to get settled back in. So I'm so glad to see so many of you joining me here to talk about these Kohberger motions. Whole big pile of motions to suppress that landed. And so we're going to go through them. I'm going to go ahead and tell you right now, don't worry. We're not going to just go through and read all of these things line by line. I've already done that. I've already read them. And so what I've done is I've taken a look at what some of the common themes are that have emerged from these, as well as the points where there are some interesting clues about facts, some factual development relating to the investigation, relating to the process and so forth. And so we are going to go ahead and go through each one, but we're not going to just, we're not going to read everything verbatim. We're just going to kind of take them one by one so we can talk about what they mean and how they fit into the litigation process in this case overall. So first off, just kind of as a matter of lingo, when we're talking about motions to suppress, we're typically talking really specifically about a motion that is alleging some type of a rights violation. It's a constitutional violation most often, but sometimes there can be statutory violations that provide for suppression of evidence that's unlawfully obtained. And the reason why this matters is because it's a very distinct type of challenge that's being made in these motions compared to just ordinary claims that something isn't admissible, something, under the rules of evidence shouldn't be admitted at trial, and so forth. So these are typically motions that have some type of almost always constitutional basis, but occasionally it is a statutory one. I have found one of the most interesting things about this case and one of the most kind of compelling reasons to follow it for me as an attorney with a lawyer's mind following this is a lot of what is going on in this case is really kind of on the cutting edge of some emerging legal issues. We kind of got a hint of that a little bit with the motion for change of venue, with just the shift to relying on the survey data to kind of go out and preview the community, provide the psychological context for how decision making works and how bias works and so forth. And it's really changing the landscape of how venue types of decisions are analyzed in that type of environment, right? Because it's so different than just the standard. You show up at voir dire, you ask the jurors if they've read anything about the case. They say, yes, they've read everything, but they can remain fair and impartial, and you're just sort of stuck with them as a juror. And so unless you get a large number of jurors that are basically willing to say, yes, I'm familiar with it, and no, I couldn't be fair, then you have a really hard time making that basis for the change of venue. So that was just a little bit of a strategic shift that is starting to take place. We certainly saw in this case, and it puts it a little bit on the cutting edge. But we're really seeing it with these tech issues being fleshed out. So first, obviously, the investigative genetic genealogy. This has been kind of the elephant in the room from a privacy standpoint for quite a long period of time. It implicates a whole different set of privacy interests than the original use of STR DNA technology implicates. And that has some fairly important legal implications as well. When it comes to DNA and the ability of police to do things like, follow you down the street, pick up the piece of trash that you put in the garbage, get your DNA from it, and use it to link you to evidence of a crime, part of the justification for that has always been that the type of technology that's been used for that, for identification, is this STR DNA technology, short tandem repeats. So just to give a very quick overview for those of you who weren't around for the IGG hearings and stuff, I'm just going to give you the brief tech overview of the difference between these. The STR is basically just looking at patterns in the genetic code where there's not coding information. In other words, it doesn't provide you with any detailed information about the person's biology, but it's just that the number of these repeats and the configurations of them they tend to be very variable between generations. And so that means they can be individualized from person to person pretty specifically. So it's just a way to be able to pull portions of the the genetic code that aren't particularly useful for anything but providing an individualized identification of a person. IgG has changed all of this dramatically because they're dealing with a different type of genetic profile. They're dealing with the SNP profile, the single nucleotide polymorphism is what that's called. And this is a much more detailed, sophisticated analysis of a human's genetic information. And it does include a whole lot of personal information about the person. That's one of the big reasons why people use these services like 23andMe and Ancestry.com and just places that can provide that both as an assistance in helping you to evaluate your background, because your genetic code can tell you things about recent geographic origin, just kind of the genetic equivalent to race. Basically where your ancestors were from. It can give you an idea. So if you're like tracing your ancestry, it can give you an idea of where your ancestors originated and kind of the pathway that they got to you. It can include a lot of information about health conditions. This is a very common reason now for people to get genetic profiling types of work done, because it can tell you about things like, for example, the only one I'm personally kind of interested in for myself is ApoE4. And ApoE4 is a gene that's been identified that has a very strong correlation to not just things like Parkinson's disease and Alzheimer's, certain types of neurodegenerative disorders like that, but also CTE, chronic traumatic encephalopathy, the disease that has been found among fighters and football players and so forth as a result of cumulative subconcussive head impacts. So it's the kind of thing that, if you have, it would be a good thing to know, maybe if you're going to have a hobby where you get hit in the head repeatedly. But I'm very concerned about these databases. And so, I'm hesitant to, use something like that to try to get that information for myself. But there's plenty of other types of information as well that comes through the SNP profile. Besides race, you can typically, get information about things like likelihood of obesity, hair color, eye color, just a wide variety of personal information about people. So the SNP DNA, it just vastly expands the amount of personal information that is now available to law enforcement through genetic research. And that really comes into conflict with these original cases that we had that looked at use of genetic information and said, well, there's not really that much that's personal about it. You typically don't have an expectation of privacy in the mere fact of your identity. And so since that's all that the STR profiling is typically providing, then we're going to just basically say it's not really that big of a deal and we're not particularly concerned about it. Well, of course, now 20, 30 years later, we're in a completely different era. And the law is notoriously slow at catching up to these types of things. So this is an interesting case from that perspective in terms of being on the cutting edge. Now, another issue where we're on a little bit of the cutting edge here, and this is, again, now bear in mind, by legal standards, because the law is slow, we're still dealing with the implications of the massive scope of digital information that is available through phones, through computers, through cloud services, and so forth. This is no longer the day where, if you are looking for information about somebody, you need to get into their file cabinet, and they might have moved certain documents to another location or put them in the attic or something like that. We're just dealing with such a massive amount of information that's available through all of these different genetic or digital databases, that it's just much harder to kind of put limits on what you're able to get, where you're able to get it. And so this is something that courts have been starting to struggle with, is kind of defining the parameters of, well, how much of this digital information really is and should be just available for law enforcement to go ahead and rifle through. Yeah, there might be evidence of a crime in there, but there's so much in there that there's just a significant risk that a lot that isn't going to be relevant, that is also going to be very personal, has the potential to be exposed. So these are concerns that have been kind of emerging in the recent years, if not months. In the case of IGG. So from that perspective, this is a fun case to follow, because a lot of these decisions that Judge Hippler is going to be asked to make in this case, these are going to have significant implications. They're very likely to lead to further review by higher courts. Again, always assuming there's a conviction, right? If there's no conviction, then things come to an end. But if Bryan Kohberger is convicted, these are the types of issues that go up on appeal to the higher courts in Idaho, and if there's no relief there, potentially to the higher courts in the federal districts. So, having said all that, let's talk about a little bit what some of the common themes are that are present throughout these motions, and then we'll go ahead and turn and start looking through them. So the real common themes that are popping up, some of the big ones, some of the major ones. First is the applicability of what's called the third-party doctrine to all of these various categories of records. This is what I mean when I talk about being a little bit on the cutting edge of the new digital era, because courts have struggled to reconcile decisions that have been made in the past about being able to access records that are held by a third party, a corporation, a phone company, a utility company, things like that, versus ISPs and other types of information service, providers, data sources, and things like that. That, again, just because of the nature of this technology, they hold so much more information than just a simple, record of how much power you used this month, for example. Another common theme throughout these motions that is also very interesting, that comes up with interstate prosecutions, is conflict of laws questions. This seems like something that, this is probably a lawyer's issue. Maybe lay people aren't going to be super excited about this one. But to me, it's really fascinating, and I'm interested to see how some of this plays out, because it's just an open question. If you are investigating somebody for a crime that was committed in one state, but you are, getting a warrant for that person in another state, and doing a search in another state, what law applies here? Who are we looking at? And the reason why this matters is because a lot of states have their own independent constitutional doctrines. So you have the federal constitution that gives you kind of the baseline, the floor for what the minimum constitutional protections are. But a lot of states will say you get more protection than that in our state. So in Washington, for example, where I practice, we have Article 1, Section 7 of our Constitution is our privacy provision. And it is significantly more protective than the federal Fourth Amendment. So when we're briefing things on appeal in Washington, The Fourth Amendment, we almost really don't even care about. It's just kind of like an aside that you mentioned because you have to federalize the issue for federal review later on if somebody wants to file a habeas petition or something like that. But the real meat of your analysis is always under the Washington Constitution, because we just we don't have the reasonableness requirement in Washington. So it's essentially just a question of, do you have a privacy interest in the thing that's going to be searched? And if you do, then there needs to be a warrant. We have very limited exceptions to that relative to the Fourth Amendment. We don't have a good cause exception, for example. Just a variety of different things that do not come up in Washington that you would be able to get away with under the federal standard. Idaho and Pennsylvania apparently have their own as well. So it just creates a little bit of a question. And then you add this other layer too when you have an FBI involved, right? If you have an FBI assisting in a state investigation in a multi-state kind of process. Are they under the federal law? Are they under the state where the investigation originated? Are they under the law of the state where the search is taking place? Seems like maybe there should be clear answers to these questions, but there aren't necessarily. So that to me is a particularly interesting issue that comes up in a lot of these motions. The third one that is a big one and is a hot button issue for me is overbreadth. This is a big, big, big issue in the digital era. And the reason why is because it hits the intersection of the requirement to have probable cause to believe that there's evidence to be found in a certain place, and the requirement that a warrant describe with particularity the area to be searched and the items to be seized. And so this is a constitutional requirement that it's responding to concerns that the founding fathers had way back in the day that the crown would basically issue just what they would call general warrants. And these were warrants that would just basically say, go take somebody's property and look through it and see what you find. They just basically authorize broad types of fishing expeditions. You can go anywhere, you can look at anything. It doesn't really have to be targeted in any way. And if you find something that, maybe it isn't even what you were looking for, but there it is, and you've got a problem with it, well, now the person whose property you've taken, now they're the ones that have the problem. So this was very, very offensive to the founding fathers. They did not like this idea that the state should have the power to just come in and disregard all of your privacy interests altogether, just for purposes of investigating a crime. So they required that those searches, they needed to be tailored. You don't get to toss the entire house. If you're looking for example, a firearm, then you can look in parts of the house where a firearm is likely to be found. And it means you can't be looking for things like, I don't know, bundles of drugs if they aren't already in your search warrant. So if you're just looking for a gun, that means you can't be going in and like opening up envelopes and, reading correspondence and things like that, because a gun is not likely to be found there. So these are the conventional parameters that have always existed around warrants, and they're much easier to apply in the physical world than they are in the digital one. So this is another issue that courts have seen a lot of litigation about in the past several years. I've litigated some overbreadth issues, particularly dealing with cell phones and warrants for that type of information. The problem that will often come up is, let's say you have an investigation for a certain type of crime, and there's reason to believe there might be photographic evidence in the phone, or there might be text messages in the phone. And so, you find that out maybe through interviews and things like that, just your timeline of kind of how the crime took place. And so under that type of information, it would be perfectly reasonable and acceptable and consistent with the founding fathers' vision for how these things are supposed to work, that you would go and get a warrant. You would identify, here's the reason why I have probable cause to believe that there's evidence in this phone. It's because I've been told that there were communications between these people. These communications will typically be stored in the phone. And so I want to, be able to get into the phone and get access to those communications. Should not have any problem at all getting that approved. The problem is, though, is that they often don't have that type of restraint. They just basically will ask for a wholesale dump of the cell phone to be able to, look through anything at all. And they might give lip service to, well, I think there's evidence of a crime in here because of communications or yada yada. But what they actually ask to seize then ends up not being so limited. So these can be a big problem, and there have been plenty of cases where cell phone warrants, for example, have been found to be overbroad because they don't put really any limit on it. They allow you to seize the entire contents of the phone and search through it without any kind of limitation based on what the actual probable cause that supports the search in the first place is based on. Some minor themes that show up throughout, obviously, as we'll get into, the Franks and the IgG, the genetic information, those are included in every motion. They're incorporated into every one of these motions. The Franks being the argument that there has been some type of misrepresentation, either overtly, explicitly, or by omission of exculpatory facts in the probable cause affidavits. The use of investigative genetic genealogy, which the defense is challenging. Their argument seems to be that pretty much everything else that was obtained throughout this investigation, it was obtained through the use of investigative genetic genealogy. And so if the genealogy itself then is constitutionally flawed, it would mean that everything that they obtained by using that is fruit of the poisonous tree. This is kind of interesting from a timeline perspective because way back when we were starting to litigate the investigative genealogy issues about a year and a half ago, that was one of the questions the defense was posing, was basically, did the investigation produce the IgG, or did the IgG produce the investigation? Because, of course, it didn't get mentioned at all in any of the affidavits. And so it wasn't until these motions were filed that we even really knew for sure that it had taken place. These motions now seem to be telling us that it was the IgG that drove the train, that they got that result back, and the investigation that they did that followed on that they're challenging through these motions, these things then relied on that IgG information. Another theme that comes up in a lot of these that I consider a little bit minor because it's certainly an issue that's worth raising, and it's not a zero issue, but it is an issue that courts will do their very best to try to find a way to fix, to correct, because they consider it sort of a technical defect, is an argument that there are deficiencies in the command language of the warrants. So basically, what is the warrant actually authorizing the person to do? That came up in the Apple warrant, the warrant for the cell phone, search of the cell phone or the USB device that contained the cell phone contents, and the Google warrants as well. So it's potentially a little bit related to this issue of overbreadth, but likely one that the court is going to find a way to cure. So as we go through those motions, we'll just kind of peek at that a little bit more closely. And then finally, the last thing, I'm not quite prepared yet to say I called it, but I think it's in there, and it's hard to say because, of course, a lot of these motions and the basis for them, it's under seal. So we're still kind of left to guess. But there are enough hints here in the motion dealing with the search of his car and the search of the parents' home that suggest we're dealing with a curtilage problem here. This is something that way back from day one on this case is something that I had in the back of my mind as a potential problem. And the reason why is because when we got the search warrants released from Whitman County, the ones that dealt with the search of his apartment, his office, and so forth, the things located at WSU in Washington, there was that strange disclaimer there in the warrant affidavit saying, here I am telling you about this 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 DNA link that we've created, but I don't actually want you to consider it, because if there ends up being a problem with that information, I don't want it to be fatal to the determination of probable cause. So it's just a real bright flashing light that even the prosecution at the time that they were filing this warrant affidavit already knew there was some type of problem or some type of potential challenge that was going to come down the road with that process of getting the profile from the knife sheath, developing it, pilfering the garbage to get the sample, and then comparing that sample to the knife sheath sample and determining, oh, the thing that we got in the trash, that's probably the father of the person that we found on the knife sheath. So the obvious problem that I anticipated with that was the garbage, being able to get into the garbage. And that's because there's kind of a little bit of nuance in this area of the law. If the police are going to come and pilfer your garbage, the general idea is that if you've thrown it away out in a public place or out where the garbage is being left at the curb, it's ready for pickup, you have abandoned it, and so you no longer have an expectation of privacy in that garbage. They don't need to get a warrant to go get it. But if police are going to come onto your property in order to get your garbage, you haven't taken it out to the curb yet. You still have it in the areas of your home that are entitled to constitutional protection. This is the curtilage is it's the exterior of the home, but it is areas that are basically still entitled to the type of protection that the interior of your home gets as well. So they can't come into those private areas to get your trash without a warrant. So this was just kind of in the back of my head for quite a long time. I think that might be an issue that is going to come out. And from some of the language in some of these motions, it appears that it may be. So with that little bit of introduction, let's go ahead and take a look at some of these motions. We're just going to kind of go through them bit by bit. And like I said, we're not going to read everything real specifically because a lot of them, there isn't much to, but we're just going to go through in order and kind of summarize what's important and what isn't. So obviously we start with the motion for the Franks hearing. They're asking for a Franks hearing, but it's all under seal. So we don't know what it is. All we know is that they are alleging that there has been information that was either explicitly misstated in the warrant affidavits or exculpatory information that was omitted that led to a misleading impression of the probable cause to support the crime. We don't know any of the details of what that is. I am very curious if any of this is going to arise from the testimony we heard from Cy Ray from back on the motion to compel hearing when he was talking about kind of looks like some of this cell site location data and the interpretations that the Moscow Police Department made of that data are maybe not really on the up and up. That when he looks at the data, he sees it as being exculpatory. So we're still in discovery, not in trial yet. Don't know how any of that has fleshed out, but do have to wonder if that is one of the issues that we're dealing with here. The only other thing that's potentially that we know of, big omission from the warrant affidavits is the investigative genetic genealogy itself. They didn't mention that at any point. They didn't tell us, hey, this is what drove the train as far as leading to the identification of Mr. Kohberger as a suspect. So if that is in fact the case, as it's kind of seeming to be implied, at least from several of these warrants, if it didn't lead the entire investigation, it at least led a pretty significant part of it. That information, the timeline, It could be relevant to the determination of probable cause, but the problem is it's really not exculpatory. It just kind of changes a little bit of the picture of how they came to focus on him. So it is possible that that's an issue in the Frank's motion, but I just don't have a strong sense that that's a particularly compelling issue for them to raise. So it likely has something to do with allegations of either like the cell site data, like we were talking about, or just other information that came up in the course of discovery that the defense has found that they think either tends to undermine Bryan Kohberger's responsibility for the crime or potentially tends to implicate somebody else in it. So we will have to see how all of that unfolds. Now, there was, as you probably saw, a motion or an order that the Judge Hippler filed to deal with the Frank's motion. And I'm just going to bring this up because it doesn't have any substantive effect on the motion at this point, but it does just kind of give us a little bit of insight into the procedure and kind of mood, the tenor of what's going on in this new court with this new judge. So the motion for the Franks hearing, he tells us, was accompanied by 38 exhibits comprising over 2,000 pages. So this is very comprehensive. They have provided a lot of information in support of their argument. What are these going to be? Potentially a lot of search warrant affidavits, the things that they're actually challenging. Typically, you want those to be in the record because you need to highlight, okay, which portions of them are inaccurate. And then you need to also present the evidence that you're saying, if you're saying this was omitted, then here's what it is that should have been included. If it's an explicit misstatement, then you need to present the proof of what the actual truth of the situation was. So it's probably some general combination of warrant affidavits and evidence. But unfortunately, the defendant's memorandum largely fails to identify with particularity the relevant portions of the exhibits, instead referring simply to the exhibit number without identifying the precise pages at issue. So it's a situation of kind of over providing and not giving sufficient detail. So couple ways to look at this. It's certainly not wrong for the defense to file all of this information. One, they need to make their record. And two, it's like if you just took out the parts that, supported the specific fact claim that you were trying to make, you would be providing it out of context. Like that wouldn't really necessarily be a good thing either. But the judge is essentially saying, you can't rely on me to read through all of this to kind of fact check the allegations that you're making in your memorandum. At the very least, even if you provide all of this context, make your record and so forth, you need to at least cite the pages that you need me to look at to confirm that what you are saying in your memorandum has some factual support to it. So he's giving them an opportunity to basically correct their filings in order to be more precise with that. So he's clearly using some strong language here. The court will not do counsel's job and scour the exhibit to decide what portions defendant must be suggesting supports his assertion. He's not going to be the one to come up with the pin sites himself. So this is clearly setting some ground rules for how he expects the briefing to go. I don't really find any of this to be problematic or particularly out of order. It's perfectly appropriate for him to call for that. I think that it's reasonable how he's handling it. Give them an opportunity to cure it, to fix it, and they have until what day? Tuesday. So, it's giving them some time to be able to fix it. Not a massive amount of time, but reality is it should be just fact, site checking. It shouldn't be that time consuming an effort for them, since they are presumably already familiar with the materials in a way that he's not. I don't have a problem with this. I really don't. I don't think this is like suggesting a real hardline attitude towards the defense or anything like that. Yeah, they really should, provide pen sites if they're using the information to kind of support a general claim rather than a specific, like, for example, if you're quoting something, yeah, you should be able to put a specific page number on that. If you are citing a pleading or a piece of evidence more broadly to support a broader proposition that you're making, such as, for example, the trend of the investigation was to do X, Y, and Z, and your basis for that is to show here's the parts of the investigation where they did X, Y, and Z, then in that sense, a general citation should probably be sufficient, but you need to be clear about that in your citation. And typically you do that by using a see generally type of citation, and you also include a parenthetical to just explain to the court, this is what I mean, this is what those citations are, and here's what they're showing that supports the assertion that I'm making about them in this general manner. So I think what he's asking for from the defense is appropriate. I think the manner that he's asking them to do it is fair. None of it seems out of line. And the reality is that this is going to now kind of set the ground rules. They're in a new court. So it would be one thing to come in and like smack things, down and just give them a really hard time when this hasn't been the pattern that they've been accustomed to, for the last 2 years. So giving them the chance, the expectation of what he has for how these things are going to be done, giving them a chance to fix it, also all seems pretty reasonable and appropriate to me. All right, the next document here. Likewise, the genetic information. We don't know what it is because a memorandum and exhibits are filed contemporaneously in support under seal. So we don't know what the basis is and we don't know what the arguments are. However, I do want to point out that genetic information, this is very broad. This is not just motion to suppress IgG, motion to suppress, a particular test, motion to suppress a particular source of genetic evidence. So, of course, until we see it, we don't know what it contains. But I read this as being broad enough to encompass, potentially, motion to suppress the evidence that was purloined from the trash, if there is an argument that that what was in the trash was within the curtilage, was within the protected area of the home, and would have required a warrant. I certainly expect that they're also raising arguments about the general constitutionality of the investigative genetic genealogy, because they refer to that through all of their other memos and incorporate that. But beyond that, we're just a little bit in the dark about what some of these challenges may be. As far as the challenging the IgG is concerned, they're very much facing an uphill battle on this. And I say that despite, when we started this conversation, me pointing out that this is really, really troubling from a privacy standpoint, because it's a completely different framework than the court was originally dealing with genetic information. When they were making these laws and these decisions, it just basically said, well, yeah, your DNA, if your DNA is out there in the environment, you've abandoned it. It's kind of alarming to think that, the comprehensive genetic database is coming. It seems like it's potentially coming. Under the framework that the Supreme Court has given us for that. There's really nothing that would prohibit the government from going to every trash can at every curb in the country and collecting samples, matching that to owners, going to schools, getting genetic information from children, Child blows their nose, throws the Kleenex away. I mean, stuff like that. And then from that, getting a massive, massive amount of personal information about everyone. This is a little bit alarming. The potential for investigations to shift dramatically based on the ability to get genetic information and then identify specific traits of the perpetrator. Now, this is one of those things that on the one hand, this looks like it could be a real boon. This could be very helpful in an investigation because it could tell you, okay, what's the approximate height of this person, approximate figure, is this person light-skinned, dark-skinned, hair color, etc. You could get a fairly decent description in all likelihood of a person based on the type of information you can get from the SNP profile. The problem, though, is that how is that going to have the potential to increase targeting? And we kind of we've seen in several cases how it can be a real problem for police to decide, well, we're going to target somebody because they fit some aspect of the case that we're trying to make. And then instead of, following the evidence to your conclusion, you end up in the situation where you just start to look for things that confirm the target that you've already put on somebody. And then when you get enough, you stop asking questions so you don't challenge your hypothesis really too hard. You just get enough, confirming it to be able to move forward. And then just, the suspicionless aspect of that type of targeting is really problematic as well, because, okay, let's say you get a suspect and the suspect tells you it's a person that meets these certain physical parameters, and there's 10 of those people in the neighborhood. One of them did it. 9 of them didn't. 9 of them didn't, but 9 of them are all going to come under suspicion. And 9 of them are all potentially going to have their privacy invaded. They're going to be potentially investigated. They're going to be potentially questioned and stuff for no other reason than because they look like somebody that left evidence at a crime scene. So that is very deeply concerning to me in terms of just the distorting effect that has the potential to have on a law enforcement investigation. This is before we even get to the problem that came out during the IGG motions, which is that there apparently seems to be good reason to think that at least the federal contractors who do this investigative genetic genealogy, they're routinely breaking the rules of these databases. These databases have been specifically set up to provide some type of protection for the people that submit their genetic information into those databases. And police are finding ways to work around it. So your genetic information, if you've used 23andMe or, any of those sources, you can't count on that being safe. And even though we heard in those IGG hearings, there's only specific databases that law enforcement can actually get into to upload a profile to and do comparisons with. The problem is that these other databases, they could be subject to a search warrant. That's happened. There's been a case where law enforcement subpoenaed one of these databases and got it so that they can do their IGG. So just the door is kind of potentially already, the barn doors may be open with the genetic information. And it's not real clear to me that there's going to be a real avenue to close it, to keep that limited. but it is very deeply, deeply concerning. So these are what I anticipate are some of the issues that have been raised in this motion to suppress genetic information. But of course, we are not going to know the details, probably not until after this trial is resolved. We might get some information at the hearing. It just depends on how circumspect they decide to be when they're making their arguments. Could be that they submit on the briefing. I mean, I don't know. We'll just have to wait and see. So very much a cutting edge issue, one that I am personally very interested in seeing how that plays out, because that is almost certainly going to it's just almost certainly going to go up to higher courts. Part of the problem that we've had with these types of challenges to investigative genetic genealogy is a standing problem. And so standing is the idea that a defendant, you don't get to just complain that the police didn't do things right, or that the police violated somebody else's rights. They basically say it's none your business. It's none ya. Unless it's a violation of your own rights, you don't have standing to be able to raise it and to be able to challenge it. So here's where that creates a little bit of a problem in terms of law enforcement, backdooring, for example, these IgG databases. The defense can't challenge it because it's not his DNA in the database. It's somebody else's. Now, if it is his DNA in the database, well, that would be a whole different situation. He would have standing to challenge that particularly. So that is always possible. We don't know. Maybe given the speed at which the IgG took place, maybe that's not an unrealistic expectation. Didn't actually have to go in and build out a big, massive family tree, because lo and behold, they found a pretty specific match right there already in the database. That is a possibility. But if it's not his, and if it's a situation where they went through and they built a family tree because other people submitted their genetic information into the database, then courts that have looked at this issue so far, there have been a few. We had one here in Washington earlier this year, I think, that looked at this question. And the general consensus around the country is you don't have standing to raise it, and you don't have an expectation of privacy in the parts of your genetic code that you share with other people. So to the extent that, if your brother's DNA is in the genetic database and you share portions of that DNA, and that's what allows them to be able to identify you through that ancestral relationship, tough out of luck. Like if everyone shares DNA, and we do 99.9 or so percent of DNA, we all share. I mean, we share like 99% with chimps, nearly all of it we share. Nobody owns it. Nobody has an expectation of privacy in it. Anybody can go in and analyze it. So the defendant can't challenge it on standing grounds, on privacy grounds. Can the people who submitted into the database challenge it? Well, not until there's a federal circuit court that says somewhere specifically that police aren't allowed to do this. They aren't allowed to backdoor the databases. And the reason why is because there is nobody to sue who is not going to have qualified immunity unless it's an issue that has already been clearly decided by a federal court in the circuit. I could do like a whole, I don't want to, because I hate 1983 and qualified immunity, but basically civil rights claims against law enforcement, they're just extremely protected. They're extremely protected. And then you can't go after the company unless the company itself did something wrong. But if the company had steps to protect your privacy, and it wasn't them that did anything wrong, it was law enforcement that found a way to work around those steps, well, then there's no cause of action against the database. So you're stuck. We're stuck. There's no way to get here because the defense can't challenge it. So you're never going to get that ruling. And there's no private way to either sue the law enforcement that broke the law, or to sue the database that got invaded. So it's going to take a legislative fix in all likelihood. This is one of those situations where probably there's going to need to be legislatures that decide to write a statute that says, hey, law enforcement, you can't be doing this. And then we get into the problem of politics and how hard it is to get that type of legislation passed, because you know who has a massive amount of power in state lobbying is law enforcement. So the wheel goes round and round. We had a motion to strike on this one as well that was denied, and this one was just based on the memorandum being over length. Now, this is based on Rule 8.1 of the 4th Judicial District Local Rules. Apparently sets a page limit for memos. This is one of these technical kinds of arguments that, I mean, to me, it's like silly to raise this. It really is. I find it just makes the state look bad to try to make arguments like this, because it is a very technical. It's just a very technical problem. Local rules, pretty much every judicial district can have local rules. Yeah, you probably should read and be familiar with the local rules. None of the defense attorneys practice routinely in the 4th Judicial District, as far as I know. Ann Taylor and Jay Logsdon are up in Kootenai County. Elisa Masseth is, I think, in Canyon County, just completely different part of the state. So I guess not shocking that they wouldn't have been familiar with the rules, or, would have overlooked it, or just something. But I mean, come on. The problem is when you have a limit like this, a form type of limit like this, you run up against a due process problem where the defense needs to be able to make all of the arguments that they need to make. And if an issue is complex, or there's a lot of facts, or there's a lot of legal arguments that are, all valid, then they have to be able to raise that, and you can't require them to waive issues in order to meet a page limit. But that said, the rules are the rules, and so they're going to have to go through this type of process in the future. The judge has just basically said these are significant and they're broad. This is not a situation where, we just didn't sufficiently edit it down to get within the page limits. There was a reason why the memos needed to be this long, because there's a lot to talk about. So had they asked for leave to file it, it would have been granted. But the state's going to get, equal page length to be able to respond, which is certainly fair. The state should not be held to a page limit if the defense is not held to one. And in the future, once again, we're just setting the expectations now. We are going to have to deal with these pro forma rule requirements, defense. So make sure that you are dotting the I's and crossing the T's. We're not going to be able to play fast and loose with the requirements. And that is a little bit maybe of a transition. It's kind of hard to say because we didn't see real formal types of challenges like this in front of Judge. But at least personally, I didn't really get the impression that he would be too much of a stickler for stuff like this. He just is more of a big picture kind of guy. We just find a pragmatic, practical type of way to solve the problem, which ultimately I think is what Judge Hippler has done here. But at the end of the day, he is making it clear we're going to follow those rules. So perhaps a little bit more of a hard line on those types of requirements. and the defense needing to follow them. So yes, there is a hint in one of these motions that there may be a little bit of a problem there, but we will go ahead and talk about that when we get to it. So let's go now to one of the big ones here, the Amazon account. The Amazon account. So here's what this is about. We'll just kind of go through it a little bit. Once again, incorporating the Franks. There's issues with that, with all of them, that all of these affidavits they're arguing are misleading in some way. So the issues, these are the legal issues, the way that he writes them out, whether he has a privacy interest, whether there is a omission, intentional or reckless omission of material information, that's Frank's, whether the affidavit includes information that must be excised. And so this is if any of the information that's included in the warrant is itself constitutionally problematic, then you have to just take that out, look at what's left in the warrant, and see if it would justify granting the request without that improper information being included. And so basically saying there's other warrants here. This stuff has a tendency to kind of create a little bit of a house of cards, right? Because in an investigation, police get a warrant, they get some information from that. Based on that information, they need to do some follow-up. So they get a new warrant where they cite the information they got from the old warrant, and then so on and so forth. And so you could be like 5 warrants down the line. And if this first warrant's got a problem, that was the one that kind of precipitated this whole investigation. You can have a little bit of an issue with that. So if there are problems with other warrants, then that's going to need to be addressed. So the facts here, the facts are very interesting, I find, in many respects. At some point, an FBI agent subpoenaed Amazon records belonging to Mr. Kohberger's accounts. So we first had this federal subpoena. And then Amazon responds with the records showing Mr. Kohberger's purchases on these 2 separate dates. So subsequently, then police go and in April, months later, they go and get a warrant asking for the same information. And the defense is suggesting this is because they knew there was a problem and they're trying to cure it, right? They're not getting a warrant because they need new information. They already have it. They're getting a warrant because they knew their process was defective, and so they're trying to fix that. Now, another possible interpretation of this is, remember, we have some implication here that the FBI has noped out of this investigation, that a lot of the information, the discovery materials that the defense was trying to get from the state that they weren't able to, these were federal materials. And so the problem was that the feds were requiring the state to go through the TUI process in order to get access to the federal investigative records. And even under TUI, the feds can, essentially give you or not give you what they want kind of within their discretion, especially when you're dealing with an ongoing investigation. If the feds are investigating something that's related, that's not resolved, or if they disagree with the findings of the state, these can all be reasons why a federal investigation would be continuing to go forward. And they may not be inclined to turn over some of the materials that they have if it would jeopardize what they themselves are working on. So another possible interpretation here is that, well, this is after the feds have noped out, and so they don't have it, and now they need to be able to get it. That is an alternative that I would just put out there. But certainly the defense thinks, well, there's at least an implication here that they're trying to cure a problem that they knew of in the first place. So there's this cutting and pasting that they point out. This doesn't really bother me because this is pretty routine. Police get to use what's called the fellow officer rule, which is basically means that in the course of an investigation, all of the officers get to rely on information provided by or within the knowledge of all of the other investigators on the case. So it just kind of like imputes this sort of police mind, to the whole investigation. So this in particular doesn't really bother me because I think that's sort of routine, but they are just trying to say, look, this isn't being done carefully. This isn't being done precisely. They're just all, nobody's really checking. They're just all kind of putting the same information out there. So originally it was Sergeant Blaker. Now they say it's Corporal Payne, but it's the same information given. So what did they rely on? This vague reference that an FBI special agent located an account for Kohberger, and it gives the email. How the agent located this was not explained. So here's where they're referring back to this federal subpoena, right? That's the implication. That's how the feds knew it, because they subpoenaed it. And you didn't mention that in this memorandum because the subpoena would not be constitutionally adequate in Idaho. It wouldn't be sufficient. So that's potentially a problem to have omitted that particular piece of information. The investigators know about Amazon records and how they worked and so forth. Little information about how Amazon collects and holds data was explained. Okay, now when we talk about the subpoena, right? The FBI agent subpoenaed Amazon records belonging to Mr. Kohberger's account. And we have this footnote, and this footnote is our hint to one of the problems. The grand jury subpoenas issued by the government have been the subject of a motion to compel. There is an order to compel their production if available to the state, or at a minimum for the state to provide dates of subpoenas. The state has done neither. The issues in the memorandum are among the reasons a copy of the subpoenas are necessary. It is unclear what the subpoena asked for or its scope. The subpoena return identifies 2 iCloud accounts. This is a little bit of a problem for the defense as I read it. And I'll tell you why, because the deadline for the discovery motions has passed. So they've already gotten a motion to compel production, and they were supposed to, turn it over probably, several months ago. I mean, if the order was June 14th of this year, typically the production is like within 30 days, within a few weeks. I mean, something like that. So the state hasn't done it, but the defense hasn't followed up on it. The defense hasn't sought to enforce it. The defense hasn't tried to get the state held in contempt, which is typically the way that you would do this. You go to court, you would say, Judge, here's the order that you signed. You required the state to do one of these 2 things. They haven't done it. They are therefore in contempt of your order, and we need a remedy. If the problem is that the feds can't get the subpoena, then that's going to call for, or the state can't get the subpoena from the feds, then that's going to call for a different type of remedy than generally if the state's got the subpoena and is just sitting on it and is not handing it over. So it kind of matters what the context is here, but it's also a problem that the defense is kind of saying right here, we need these subpoenas to be able to make our legal arguments. I mean, there might be an overbreadth issue here too. It seems a little bit less likely just by the nature of the requests that are made that we'll talk about there too. But if you don't have the subpoenas that are necessary for you to make your motion, you're not going to be able to make the record that you need to get the relief that you're asking for. So this is an issue that looks to me like, maybe Judge would have been receptive to this type of argument that, hey, the state was supposed to do this and they haven't. And so we can just kind of bootstrap a contempt argument into the suppression argument. I don't get the impression that Judge Hippler is going to be real accommodating like that. He was not happy with the motion for leave to extend that the defense had filed. So because the deadline for the motions to suppress and the deadline for discovery motions fell on the same day, they filed all of these motions to suppress. They didn't file any discovery motions, but they filed this very general motion for leave to basically extend the deadline to file discovery motions. And the judge said, no, you haven't shown me cause, either why you need to file discovery motions, why you couldn't have done it, or why you couldn't have done it already. And he is a little bit, more firm in that one, that it's not really very well taken. And again, I got to say, I don't necessarily have a problem with it, because he's not wrong that it was just sort of this generalized, well, we're busy, we need more time. And, you probably do need to be a little bit more specific. There needs to be some explanation of what is it that you need to do. Why haven't you been able to do that so far? And what's the implication, if we aren't able to do it? Now, it's not unheard of. Defense will, often throw themselves on the sword, be like, look, I messed up. I'll be ineffective if I don't ask for this. And you just make that record for the, future appellate counsel, if they're, again, looking at this after a conviction. Here's something that they didn't do. They're telling me on the record, that they were ineffective for not doing that. That can be a way to kind of, put a judge in the position where they have to evaluate, should I just go ahead and make an exception then and let them do it anyway? Or should I say fine? Then you're going to be, ineffective, and let the appellate courts sort that out. Just depends. Different courts have different approaches to that. But obviously the defense hasn't done that at this point. I don't know if they would. My suspicion is that if it turns out there are discovery items that need to be followed up on that they haven't done, then they're going to just need to ask for the leave specifically. They're going to need to do what Judge Hippler told them you should have done in the first place, and just make a better showing of, here's what it is that you need. Here's why you weren't able to get it sooner. Here's why you weren't able to raise this issue sooner. Bring it to the court's attention in a timely fashion, and then see how it's dealt with at that point. So, little bit of a concerning footnote there, because don't know at this point that the defense is going to be able to get the subpoenas that they are saying they need to be able to make their arguments. The other reason why I still find it factually interesting, though, is because, this federal grand jury. We're back now to hearing about this federal grand jury. The federal grand jury is a very interesting detail. And the reason why is because federal grand juries, they don't investigate purely local murder cases, which this is. Federal jurisdiction over murder is extremely limited. It's extremely limited, and it's not going to be implicated by something like Bryan Kohberger crossed state lines to do it. It might sound like that would be a basis for federal type of jurisdiction. It probably would be a basis for Congress to pass a statute saying the FBI or the Department of Justice or whatever can have jurisdiction in that type of circumstance, but they haven't done that. So federal murder is very limited. There's like a few specific categories. If it involves a bank robbery, murder in the course of a bank robbery, murder of a judge. These are just some of the examples I remember off the top of my head. A Major Crimes Act that involve crimes between Native Americans on Indian reservations. We're not dealing with those types of very specific circumstances. We're just dealing with, an obviously gruesome and terrible, but normal local murder. So for the feds to have a grand jury investigation going on, there's something else that they're looking at that is a federal. does have a federal hook. And I don't know what that is. I don't know what that is, but I'm very, very interested to find out, because that is an interesting fact. Another interesting fact here, the time frames. So remember, what we know about what they got from the warrant was they got purchase records. And they got purchase records for these specific time frames. March 20th to March 30th of 2022. And then November 1st through December 6th, 2022. I got to wonder what this is based on. I mean, they clearly have some information that led them to look at these dates. Don't know what it is. I don't know what purchases they're looking for. The obvious, of course, everyone is going to assume, and I certainly would assume too, well, they want to look and see if he bought a K-bar knife, match the knife sheath that was found at the scene. But if he bought a K-bar knife in December, it wouldn't be relevant. It wouldn't matter. Would it? So this, all the way to December 6th time frame is a little bit, it just raises a red flag for me, because it raises these questions about overbreadth. They're not arguing that in this particular motion, but again, that's because they don't actually know what the subpoenas were for. Unclear what the subpoenas asked for or its scope. So they don't know what information the feds already had or had already gotten that led to this particular piece of information. So something in there that they have suggests that these time frames are relevant, but as of now, we don't know what that is. Maybe we'll hear about it when we get the state's response. So I'll be keeping an eye open for that when those come down. This argument right here, this is one of the best descriptions of this challenge that I mentioned at the beginning as kind of a theme to all of these motions, that there are concerns about records that are held by third parties that would ordinarily fall under this third party doctrine that does not require a warrant in the digital era, because just the type and amount of information is so much different that courts have had trouble reconciling how they want to handle these types of requests in these types of areas with this type of information. So we're dealing on the one hand with federal standards, right? Legitimate expectation of privacy in the item or place searched. And based on that, we have this third party doctrine that says you don't have a privacy interest in your bank records. Did you know that? By the way, did you know that the feds can go to the bank and get your bank records, and they don't need a warrant for that as long as the bank says okay? And what they will typically do is just get some type of subpoena or something, so the bank has some cover. They're not just willy-nilly handing out your financial records to just anybody. But they aren't required to go through the process of showing cause to a magistrate to support reasonable belief, probable cause that there is evidence of a crime in your bank account records, and that it will be found there. It can just be, hey, we got a grand jury thing going on, and we think it would be helpful to look through your bank records. Fish away, get that subpoena. So under this federal doctrine, If information is shared with anyone with whom a person does not have a recognized evidentiary privilege, it is free for the government to take without a warrant. So what this means is that the third-party exception doesn't apply to things like your medical records. You have a patient physician privilege that typically attaches to those types of records. It doesn't apply to attorney-client communications. Okay, the attorney is a third party. You share information with them. Normally, under this doctrine, everything else being equal, if it was just a random person, they don't need a warrant to go get that information from that third party. But because you have a common law privilege of confidentiality with your attorney, it doesn't apply in those situations. But outside of all of those other, those limited situations, everything else, all of the vast amount of data that's out there about you that's held by third people, yeah, they don't need a warrant. That's what the third party doctrine, if you follow it to its logical conclusion, that's what it's going to hold. And so the problem that has come up in practical reality here is that in the modern world, you kind of have to give up a massive amount of your personal information and your privacy just in order to participate in life. To be able to make telephone calls to people, to be able to, get online. A lot of government processes now, you have to get online. That means you have to have a computer. That means you have to have an internet connection. That means, it's going to identify your devices. From your devices are going to all capture history that might get uploaded to something like a cloud. So basically, unless we're just all monks, and we only use the digital world for the things that we, minimally have to, then yeah, you're giving up. You're giving up a massive amount of your privacy under this conventional third-party doctrine because the ISP can provide it. The iCloud or Google account or whatever that stores your data, they can provide it. The web browser, if you use a browser that keeps your bookmarks and things like that, they can provide it. These are all just third-party corporations that are collecting our data. Kind of a little bit alarming, isn't it? Now, Idaho has, they're pointing out, again, Idaho free to apply a more protective standard than the Fourth Amendment. And in certain cases, they have done that. So, but they have this mixed record where, okay, health records can be provided to the government. Billing records can be provided for the government. Your trash, right? This is very common. You put your trash out there for pickup, no expectation of privacy there. However, all the way going back to 1988, you do have a right to privacy in who you call and then later the text messages that you send. Well, those would be in the possession of the phone company. So it's not real clear why we would distinguish these types of third-party records from the other types of third-party records. And so you get inconsistent decisions depending on what exactly it is that the state is trying to get. And that's a problem in a lot of places. It's just a problem with legal reasoning in general sometimes, is that you have a general principle, it sounds really good, but then when they actually want to try to apply it in a specific situation, they're like, well, but maybe not that one. And kind of the classic example of this one for me that always comes up is Gonzalez versus Raich. This was a Justice Scalia opinion that held that the Commerce Clause allows the federal government to regulate the entirely intrastate growth and personal use of marijuana. And it's just a case where prior to this decision, it relied on this old case, Wickard versus Filburn, that dates back to the Great Depression, when there was a lot of regulation of crops and crop prices, and different price supports and different restrictions on shipping and all this type of stuff, because they were dealing with both inflation and then farming not being profitable, right? Farming not getting enough of a return on your crop to such an extent that it was more to your benefit to just junk your crop than to bring it to market. And when people are hungry, that's not a great thing to be doing. So Wickard v. Filburn basically upheld this federal statute that said, or it was a decision basically that applied a federal statute dealing with wheat growing and wheat regulation to a guy that was just growing his own wheat on his own farm for his own use. And the Supreme Court said, yeah, we don't think there's any problem with the federal government being involved in this, even though it's taking place entirely within this one state, because it's part of this bigger market of wheat and crop regulation. And so, like, by growing his own wheat, he's not participating in that market. And that means he's kind of taking himself out of the regulatory framework that Congress otherwise has the power to be able to adopt. So, okay, like under that circumstances, maybe we can see a little bit of a justification. Maybe, I mean, Wickard v. Filburn gets really, really criticized by a lot of people, including me. I don't think it's a very good hook for congressional jurisdiction. But thinking it's bad and then applying the notion that it's bad to marijuana, that's just going to be a step too far for certain folks. And so it's a kind of common problem in the law, is that you end up with what is often just outcome determinative reasoning. It doesn't end up being inherently and internally all that consistent. It's supposed to be based on principles, but the problem is that when push comes to shove, they just don't like how the principles apply in a particular case. And so, that's got to be reasoned around. So Idaho has struggled with this. They're not the only ones. Indeed, the U.S. Supreme Court has said cell phones are different. Cell phones are different, and cell site location data, pings require a warrant under the U.S. Supreme Court precedent. That was an issue I litigated in Washington State right about the same time that Carpenter was coming down. Pings. They're not yours. It's cell tower data. You don't even really have access to it. It belongs entirely to the cell company, but it's produced entirely based on the interactions of your phone with that network. So these are situations where the Supreme Court has said, well, cell phones are different. And the reason why is because there's a massive amount of information that's available in the digital world. This is what we're talking about. This is a little bit different than the old days where I could go get a paper record from AT&T and it would show me the number that was dialed and the time and the length of the call. And, that's all that I'm getting. It's a little bit different than, the old days where I would go to the grocery store. You'd go to the grocery store and you'd get the receipt roll, for that day, the tape, and you'd go ahead and, because you knew somebody had, made a purchase in there at a particular time and you needed them at that location, and you would just go through that tape, till you found that time, that transaction. A little bit different when you're dealing with cellular information, because there is a massive amount of it available. So they're describing how I will say this. This is I'll double check. Let me scroll down to the end real fast to make sure, because I'm pretty sure it is. Yes, this is Jay's memo, and I really like Jay Logsden. I did put him on the thumbnail for a reason. He's clearly a very smart guy, but his writing can be a little bit obscure sometimes. It can be difficult to follow his reasoning because he has a tendency to just kind of drop things and sort of assume that you know what he's talking about when he goes on and makes a certain type of comparison. So he's relying on Professor Oren Kerr, who's he's a law professor that is like probably one of the most prolific authors of law review articles. He just like studies everything. He writes and publishes articles about pretty much everything all the time, like dozens of them a year. So he apparently has defended this idea of the third party doctrine, this idea that if the records are being held by a third party, you don't have any interest in it. And what he says is that in Miller, the checking account created a substitution effect by replacing a transaction that would have included substantial public components with a transaction that would normally occur entirely in private. So the idea is before checking accounts, if you wanted to go get money and pay it to somebody else, you would have to personally go to the bank, right, where you could be witness doing it. You would have to get the cash from the teller where somebody could see that happening. You would have to put the cash in your pocket. Then you'd have to walk over to the person who you owe the money to, hand it to that person, and so forth. So all of these things potentially are occurring out there in public where you wouldn't necessarily have an expectation of privacy. But then by creating a checking account, the banks allowed you to take that out of public view. So I no longer have to go to the bank in person. I can just write this transaction in the privacy of my own home and stick it in an envelope and put it through the US mails where nobody is supposed to ever see it. And then you can't track that money the way that you can if I have to go in person to the bank. So that is how he describes Professor Kerr's justification for the third party doctrine, that it was originally public. You wouldn't have had an expectation of privacy. The bank kind of created this mechanism for you to be able to do it in private, but that in and of itself is just kind of a side benefit to you. So the fact that they have the record of that transaction doesn't mean that their record is entitled to constitutional protection. But the problem is you can't apply that same reasoning and get to the same result that the Supreme Court got to when they said, well, but cell phones are different. Because there's a massive amount of data that's available on a cell phone. Your entire life is available on a cell phone. The places that you go, the people that you talk to, the things that you think about, the things that you look for, the things that you read, the places you send money. I mean, it's just more and more all the time. You know, even 10 years ago, 15 years ago, when the Supreme Court is deciding these types of issues, you know, for the first time. Even since then, there's a lot more that you can do now on your cell phone compared to what you could do even just 10 years ago. So it's more and more all the time, and it's just a more and more comprehensive view of who a person is and all these things that have conventionally been protected. Your consumer choices, your political affiliations, your associations. And there's a whole industry now in capturing your data and running it through all types of analytics so that they can try to figure out who you are and then use that to target advertising at you. So his argument is that the Supreme Court, their reasoning is very inconsistent, and it's hard to make sense of why they would say the third party doctrine applies in some cases and not others, and that's a problem when we're talking about, does the third party doctrine apply to this particular set of records that we're talking about? Amazon purchase records. We have to understand the reasoning to understand are we going to treat Amazon records more like a cell phone or more like a bank record? Now, Idaho, on the other hand, he points out now, turning away from the federal standard, going back to the Idaho standard, they have more protection for people that we call. So federal government says phone records, now you can go ahead and get those without a warrant. Idaho says, no, you can't. Idaho says we're going to find an expectation of privacy in there. And so that court basically said whether privacy expectations are legitimate within the meaning of Katz, just earlier case, depends not on the risks an individual can be presumed to accept when imparting information to third parties, but on the risks he should be forced to assume in a free and open society. This is the argument that, hey, if you know that the cloud is capturing all of your data, the ISP is tracking every website you go to and so forth, that by continuing to do those things, you know what the risks are. You're giving it up. It's not a secret. And so therefore, you're not entitled to any privacy in all of this behavior that we engage in online. Is that reasonable? Is that the standard we should accept in an era where it would be pretty hard to function in the world without having some type of digital presence? I mean, I don't think we really want a standard where we're looking at like Ted Kaczynski as kind of the way out of this morass. That you just have to back away from the technological benefits of modern society, or you will have been assumed to have, assumed all of the risks of that and accepted. All right, well, I'm under total surveillance then. All of my information. I know that everyone's got it, and I'm just giving that up. I'm late Gen X, and so I remember when the internet was new. I remember when the internet was new, and I remember this idea very early on and very long ago that, oh, you were going to have to be, so careful, the internet's forever and all that stuff. And we still have this idea in our minds about how vast and perpetual the information that we put out into the digital world is. But do we really accept that? Is that how we really function? As if, oh well, it's just open to anybody. I mean, would it be better if we functioned that way? I don't know. These are complicated questions. That's what I'm saying. This is why this is very compelling stuff from a kind of cutting edge legal perspective, because these are decisions that we have to make that have the potential to affect the fabric of our society. And yeah, expectations of privacy. Do we have them anymore in the digital era? If we want to have privacy in the digital era, what are our options really? So he basically what he's doing in this part of his argument is that he's trying to reconcile the Idaho decisions where they say some things we fall under the third party doctrine, some things we don't, by pointing out garbage is open to the public, doesn't carry duties of confidentiality. There's no confidentiality, owed by garbage handlers. But telephone calls They do. There's like communications privacy rules and things like that. But then we have this Mubita decision. This is one where they basically said that a person's HIV status can be disclosed to the government without a warrant. It's just the nature of the information that's sought has some type of public implication, public safety, public health implication. And so ultimately he kind of reaches this conclusion where he says, ruling about bank records shouldn't apply. Miller, the U.S. Supreme Court case that led to this third-party doctrine, it doesn't and shouldn't apply here. And the reason why is because these records are very different from bank records. And here's why. Here's what Amazon.com behavior can provide. Your name, address, searches, recordings when you speak to Alexa, your orders, content you watch on Prime, your contacts if you upload them, communications via email, cookie trackers. Some of it's used for personalization, purchase dates and payment and delivery information. From this, Amazon can work out where you work, where you live, how you spend your leisure time, who your family and friends are. At the same time, Prime Video and Fire TV information about what you watch and listen can reveal your politics, religion, culture, and economic status. If you store photos, facial recognition is enabled. Geolocation tags, device information, attributes of people and objects featured in images can be available. The Kindle e-reader collects data about what you read, when, how fast you read it, what you've highlighted, book genres. That could reveal a lot about your thoughts, feelings, preferences, and beliefs. How often you look up words might indicate how literate you are in a certain language. It can add up to a lot of data. Every motion detected by Ring doorbells and each interaction with the Ring app is stored, including the model of the phone or tablet and mobile network used. Ring can share your stored data with law enforcement if you give your consent or if a warrant is issued. So what he's doing here is he's giving, I think he's making a very good case about the breadth of the type of information that's available from Amazon. The problem is it's not quite on point because the only thing that's at issue in this particular warrant, as far as we know, is purchase records. So it isn't necessarily going to implicate all of these other things that you can get on Amazon. Now, some of the other warrants that we get to, this is potentially a lot more on point, at least in my opinion. But the purchase records aren't going to implicate things like what's stored on Prime Video or Fire TV or how fast you read your Kindle or what's on your Ring app and so forth. Those are potential things that are available from Amazon, but they're not necessarily implicated by this particular warrant. Purchase records are going to be far more equivalent to something like a receipt. Seems like to me. And typically receipts don't necessarily get all that much constitutional protection. You can walk into a grocery store, ask for the receipt. Sometimes they'll just give it to you. In fact, it's fairly common in like shoplifting cases, things like that. Walmart's kind of notorious for this. It's something they've taken a lot of criticism for, that they sort of offload a lot of their loss prevention onto local law enforcement. They don't do a lot of the work themselves to stop and investigate theft. But very common in situations like that for police to just walk into the Walmart or the Home Depot or whatever, gotten the report, get the information, get the video, get the transaction records. There's no warrant required. They can just voluntarily hand that over. So I suspect that that might be a little bit more of the framework that we end up in this particular motion. But that said, I generally like this idea. He does say, as for Idaho, no doubt that Article 1, Section 17 requires a warrant before law enforcement can access an Idahoan's online records. And he distinguishes it from the other cases. It's not garbage you leave on the street, nor is it HIV information that society has a stake in knowing. Well, two problems with this right here. One, online records, that's very broad. That's very broad. And I'm not sure that that necessarily follows, because he would be seeming to say then that any information that's stored digitally, Idaho gives it a greater expectation of privacy than the federal government does. And that seems to not be supported by at least anything that he's cited. Bryan Kohberger isn't an Idahoan. This may seem like a little bit of a technicality, but it might not be, depending on what's your reason for saying that Article 1, Section 7 requires a warrant before law enforcement can access an Idahoan's online records. He's not in Idaho. He's in Washington. And the feds got it through, a federal subpoena. So we've once again, they didn't actually raise it in this particular motion, but we do have a little bit of an issue potentially with the conflict of laws. What law actually applies here to an Idaho investigation against a Washington resident by a federal grand jury? It's messy. I don't envy Judge Hippler having to sort this one out. So at the end of the day, I like this argument, but I don't think it's going to work, just given the fact that this particular warrant was very limited in scope. It wasn't for all of his Amazon records. Had it been, I think we might be talking about a little bit of a different issue. But is the court going to say you can't get the Amazon purchase records because too much other information is available from Amazon? I don't think so. And the reason why is because that's kind of the answer to this other problem that gets raised with these other searches, the overbreadth problem. If the problem is there's too much data available through Amazon, then what we need to do is we need to require law enforcement to be very specific about what they're looking for and why, and then to be limited in what they're able to access. And that does seem to be what they did here. It's limited to purchase records, and it's just within a certain date range. We don't know why. That hasn't been made clear to us, but it's not his entire Amazon account. So I don't think this one probably has a very good chance of being granted, but it's an important point, and a lot of points that they make there are going to have just as much weight, I think, and importance in terms of the types of inferences that can be drawn about you based on the scope of information that some of these digital sources have. It really is vast. It can tell you a massive amount of information that ordinarily would not have been available. So then we get to incorporating the Franks warrant. This is just a little bit of briefing that says, they're incorporating the warrant. It's based on the Franks. And so in addition, the affidavit for the Amazon search warrant did not explain to the magistrate that federal agents had been talking to Amazon and issuing subpoenas, and that was how they had gathered information for the affidavit. Mowry intentionally failed to disclose the illegal means by which the investigators had, quote, located the Amazon information. That's a pretty good point. It's a pretty good point. If he knew they got it from a subpoena, and he knew that there's potentially a legal problem with it being a subpoena and not a warrant, that could be an issue. That said, I don't think it probably will be because of the fact that this is a novel legal issue. You wouldn't be able to say Detective Mowry knew that a warrant was required to get this information from Amazon if there's no case law that says you have to get a warrant to get this information from Amazon. So it's a good argument and a clever argument. And I think it's important to point that out, but not because I think it's likely to help them out in this particular context, but just in terms of getting the flavor of the investigation established for the court as it's deciding the Franks issue. Information that must be excised. So everything relating to the unconstitutional use of investigative genetic genealogy. Of course, we don't know what their argument for this is, why it's in violation of the Constitution. But there would be no investigation into him without the original constitutional violation. This is now hammering down that timeline back when they were first questioning what came first, the chicken or the egg, the Elantra or the IgG. And it seems now that we have the answer. The answer is, at least according to them, it was the IgG that drove the train. They focused the investigation on Mr. Kohberger, a person whose only connection to the case was his mode of transportation and the shape of his eyebrows, two identifications of little to no value. Yes, there's probably a lot of bushy-eyed men who drive white cars in this area. They have in Idaho an inevitable discovery exception. So we actually don't have this in Washington. You don't get to do that. This idea is that, well, okay, you got information illegally, but you would have gotten it anyway through some other legitimate means that can cure this defect in your warrant, because it wouldn't necessarily, you can't necessarily say it's fruit of the poisonous tree if it could have been obtained and incorporated through other methods. But they say without the IgG, there is no case, no request for his phone records, surveillance of his parents' home, no DNA taken from the garbage in his driveway in a gated community under a garbage collection ordinance. On his driveway. This sounded a little curtilagey. In a gated community under a garbage collection ordinance. It adds a fact, the gated community adds a fact as far as, is this an area that you would expect to be open to the public? Certain parts of your house you expect to be open in the public. You generally expect that somebody can walk up to your front door and knock on it. Now you can put a sign on your door to limit that says, no solicitation, for example. And then if somebody violates that, they're trespassing. They're exceeding that limit that you've put on their permission to knock on your door and disturb you inside. But it doesn't mean that they aren't entitled to walk up your front steps. Now, just because people can walk up your steps to your front door doesn't mean that, if you're not there, or you don't answer the door because you look out and you see it's a solicitor. It doesn't mean that they then are going to have the right to come off your front porch and start peeking in your windows to see if you're there, go around to the back, check and see if you're there. Is that something you'd think is reasonable? I think a lot of people, you might be met with a protect a home defense type of situation if you were to do something like that. Go peeking in the windows. That's outside the realm of what there is a reasonable expectation that the public is allowed to do. So the question is going to be, where in the driveway? Does the gated community matter? The gated community is typically going to limit access then to people within the community and their guests. Is that enough to say, well, I've exposed garbage to all of these people? to potentially be able to get it, that therefore it could be exposed to the world as a whole. Possibly they would say that. Under a garbage collection ordinance, I don't know what the ordinance is. I don't know what it provides for. It could matter. It could matter. Is the garbage supposed to be sealed in a certain way? I don't know. So I'm curious to know more about this, but boy, oh boy, does that language sound like a curtilage issue. And then anything gathered from previous invalid warrants must also be excised. So anything in the Amazon warrant from April of 2023 that relied on the results from warrants obtained before that are not constitutional has to be excised, and then they have to reread the warrant and decide, is that enough? We take out all this illegally obtained information. Is that going to be enough? The Amazon warrant was one of the, or the Amazon motion, it was one of the bigger ones. And it also gave us kind of the first look at that real third-party defense, that third-party argument that came up in so many of these other motions. So we spent a little bit of time on this, but some of these other ones are nowhere near as comprehensive. So this one, to the search warrant for his apartment, this was the one out of Moscow, or out of Pullman. Sorry. So this was from Whitman County, and they have this again issue with the facts. We learned a little bit about the facts. And so this interesting sequence of events that they spell out. So we have the Pennsylvania State Police becoming aware of the objective of arresting Mr. Kohberger on December 28th of 2022. December 29th, 2022, Pennsylvania magistrate issues a search warrant for his person. And December 29th, 2022, the Latah County magistrate signs an arrest warrant for Mr. Kohberger. The basic facts, we kind of know these facts already. Tan leather sheath, single source of male DNA on the button snap of the knife sheath. Footage from the neighborhood showed what they believed or suspected was the vehicle of the killer. It lacked a front license plate. They decided ultimately that it was a 2011 to 2016 Hyundai Elantra. Vehicle matching that description was spotted via surveillance in Pullman. Later discovered Mr. Kohberger drives that 2015 car, lives not far from the last place a white sedan was seen driving in Pullman over an hour later. And that the car seen in Pullman was a 2014 to 2016 Hyundai Elantra. Dylan Mortensen had indicated the height of the person she saw at the time of the attack was between 5'10" and 6 foot. That's a fairly specific height estimate. And they had bushy eyebrows, and that police determined Mr. Kohberger fit that description. We might still be arguing about those bushy eyebrows, but well, it's in the eye of the beholder. See, that's the problem with a description like that. It's completely unfalsifiable. Maybe I have bushy eyebrows. Do I have bushy eyebrows? Relative to lots of people, I do. I don't think I would call them that, but records from the August traffic stop showed he was the driver of the Elantra with Pennsylvania plates. He lacked a front plate. Gave his phone number, learned it was an AT&T number, changed his vehicle registration to Washington, November 18th. Cell tower records did not show he was in Moscow, but in the experience of law enforcement, people committing crimes typically turn off their phones. Do they now? No, they typically do not turn off their phones. They might sometimes turn off their phones, but typically turn off their phone? No. No, I can't say that's correct. The CSLI data went to the CAS team, determined that on November 13th at approximately 2:42, his phone was utilizing cellular resources that provide coverage to his apartment in Pullman, support the idea that he left his apartment and went south, support the phone being off. Then at 4:48 a.m., the phone was south of Moscow near Blaine, and then utilizes resources making their way back to Pullman, coinciding with a light white Elantra seen on some surveillance there. And similar data showing occurs approximately 9 o'clock a.m. with a trip to Moscow and returning home at around 9:32 a.m. The same team determined Mr. Kohberger had been to Moscow on at least 12 occasions prior to the event and that he came into the area the morning following the murders. However, law enforcement without explanation indicated that it did not believe that final trip ever occurred, right? The going back to the scene the next morning, that whole part of the narrative of guilt. He went back to the scene to see what was going on. Law enforcement said in their own documents, they don't think that happened. But they still don't know why. That's just peculiar to me. I've kind of assumed that it must have been a situation where they could document him being elsewhere. They could establish he was somewhere else. He was in class. Maybe not on Sunday. He was in the library. I mean, something. He's on video somewhere. But it's just a bit odd that now, having said this, the defense here is just recounting what was in the search warrant at the time. And so it's possible and hopeful, I would certainly hope the defense now knows why law enforcement said that. Why did you say that even though you're saying his phone pinged off of the tower, and that's the same ping that you're saying means he was there for the murders, but you're saying that same ping the next day happened when he wasn't there, for any reason. This is a big inconsistency, a big problem with the use of the cell site location data and the justification for drawing the inferences from it. And so we still don't know what that means or why. But I got to hope the defense knows about that by now, that they've had an opportunity to either find it in the discovery or ask the detective. So when you put that in your affidavit, what was that all about? So they got the criminal complaint and probable cause on December 29th. Pennsylvania SWAT began preparations to arrest him despite days of constant FBI surveillance. Pennsylvania law enforcement did their own starting at 11:15 p.m. And despite the fact that constant FBI surveillance showed Mr. Kohberger was unarmed and tended to go for runs around his parents' neighborhood, police decided that in the dead of night within his parents' home was the way to make their arrest. A lot of these facts are they're just repeated across all of these different warrant affidavits. And so this particular fact doesn't really necessarily matter much for this challenge, but it definitely does matter for the challenge of his parents' home. Probably just tending to show there is some cutting and pasting going on here when it comes to the factual assertions. 9:25 Pacific, so 12:25 on December 30th on East Coast time, Superior Court judge in Washington issued a warrant for his apartment in Pullman, Washington. It was based on the affidavit of Assistant Chief Don Daniels of the WSU Police Department. They requested the assistance of WSU police in investigating the case, and it relied on the same information that was set forth above. And then within 45 minutes of that warrant being signed, 50 minutes, Pennsylvania SWAT and federal agents raided Mr. Kohberger's parents' home. They arrested him, and then later that day, they searched the apartment. So the first issue we have here is this one about the conflict of laws. Whose law even applies in this situation? Are we looking at Idaho law? Are we looking at Washington law? Are we looking at federal law? It's actually not all that clear, and there isn't necessarily good guidance on what the rules are supposed to be. So he goes back to Professor Kerr, who, of course, has written a law review article about this, because he's written law review articles about everything. And basically points out there's a lot of different ways that that courts have resolved it. Idaho and Washington are analogous in certain respects of the Fourth Amendment. If they were going to apply Washington law to this search, generally it's going to be under a much more protective standard than certainly the federal Constitution, and probably Idaho's also, because Idaho's Constitution also uses this reasonable expectation of privacy type of construct. Washington does not. Washington's Constitution does not use reasonable expectation type of language in it. It says pretty explicitly those privacy interests that Washington residents hold cannot be invaded without authority of law, period. So it's not, is your privacy expectation reasonable? It's, is it private? So if we're applying to Washington law to this search, it's probably going to be under a stricter standard than if we apply to Idaho. But not at all clear whether a search should be judged by Idaho's standards of reasonableness or that of Washington's, or in the case of the FBI agents, by the Fourth Amendment. So Professor Kerr, his recommended method is to use the law of the jurisdiction where the prosecution is going to take place. And that does kind of make sense because it's your standard. And the reason that you have exclusionary rules in the first place is to basically protect the integrity of the investigations that are being conducted under the authority of your court. And so if police are violating your rules, that's a little bit of like a flouting of your authority, right? So it goes to protecting the integrity of the process for the court to say, these are my rules, you have to follow my rules. So it does make some sense. And they're suggesting, in fact, that's what they should do. The court should be required to apply Idaho search and seizure law to their actions in Washington. Wouldn't necessarily get them, get them more protection, but it potentially would get better protection than applying the federal Constitution. But the situation has its detractors because there is a concern that you could permit forum shopping. If you're looking at the law where the search is taking place to govern, then you can just wait until the person moves somewhere else, or you can like try to arrange things. You can have ploys or whatever to try to move people or move evidence or whatever until it gets into a jurisdiction where there's a more favorable standard. So it does make sense to have something that is a little bit more formulaic, I guess. And then finally, it must be said, very little daylight between the Idaho Constitution and the Washington, and Washington appears to have stricter requirements for probable cause. Yes, indeed we do. We have stricter requirements for pretty much everything when it comes to search and seizure. So this is some briefing that if I'm the judge, I'm a little frustrated with this because, I mean, they are telling me what they want me to do, which is helpful. Okay, the court should be required to apply Idaho search and seizure law to their actions in Washington. And they are telling me here's what the justification is, right? It's the authority, on these types of arguments, the scholarly authority, and it's based on some case law as well that applies these types of principles and this general idea of agency, that it's really an Idaho investigation. And so it's the rules that apply to the Idaho police that should govern. To the extent they are overseeing what the feds or what the Washington police are doing, they should be held to account for under their own standards. So they are telling me what they want, and they are telling me why. But this is annoying. This is an annoying issue when you have to start by not even knowing what rules you apply before you even get to applying the rules. That's irritating. It is. But it seems to be an issue of pretty much, if not exactly first impression, but defense could not find a precise case on point for the state of Idaho. That means it's pretty close to an issue of first impression. So no pressure, judge. I mean, it's going to get reviewed no matter what if he gets convicted. So we get back to the Franks issue here, right? And then IGG and any other invalid warrant. So here's what this is telling us. There's no real independent basis for having a problem with this search warrant for his apartment. There's not anything beyond Frank's, exclusion of data, of information, or IGG is unlawful, or it relied on other illegal information. There's nothing independent that in and of itself challenges this particular search. There's just this added legal question of what law, by the way, what law are we looking at this particular one through? So they will need to make that decision. But otherwise, this is just a situation where if the Franks is granted, then this is implicated. And if the IGG is granted, then this is implicated as well. So then we've got this. Oh, hang on. Did I skip one here? No, I didn't. The Apple account. Okay. Well, incorporates the Franks once again. The issues, the privacy interest in his Apple account information, the Franks issues, the IGG, previous invalid warrants. There's an also specific affidavit that includes information that must be excised. The fail to command law enforcement to search the Apple accounts or contents of the iCloud. This was the minor theme I pointed out. So we'll go ahead and discuss this one a little bit more specifically in a moment here. And then the search warrants fail to provide specific particularization of what to search. This is the overbreadth argument. So our facts here. December 21st, 2022, FBI issued a preservation request letter to Apple. And then on December 30th, 2022, Pennsylvania law enforcement, along with officers from Idaho and the FBI, raided Mr. Kohberger's parents' homes in Albrightsville, Pennsylvania, and arrested him. Okay, so what we know from this, at the very least by December 21st of 2022, the FBI is looking at Mr. Kohberger. An iPad was located in the parents' home, but it was not seized because it was found in a common area. During a subsequent search of Mr. Kohberger's vehicle, a receipt was located for an Apple iPad based on incomplete records available to the defense. FBI served a grand jury subpoena on Apple on January 12th, 2023, and Apple produced responsive data on January 27th for these two Apple accounts. Data was shared with Corporal Brett Payne. Subsequently, Apple sent an email to FBI tactical specialist acknowledging receipt of a preservation request on April 6th of 2023. Over the next few days, Detective Mowery was included in an email chain discussing Apple's response to the preservation request. And they reference setting up a chat with Apple's point of contact to discuss issues that need clarified or resolved, and also include Apple telling law enforcement which accounts do or don't exist for Mr. Kohberger. So once again, we have a subpoena first that's then followed by a warrant quite a bit later, now more than 6 months later. Once again, we have this problem where we're relying on these grand jury subpoenas that the state has been supposed to produce, but they haven't. But the defense hasn't done anything to compel them, to have them held in contempt, to force it to happen by the deadline, at least in theory, for them to do that. So unless they have an argument that the contempt falls outside, it's not discovery litigation, doesn't fit under that deadline, maybe, but that's going to be pushing it, then this is just not good. This is not good that they needed the subpoena. The subpoena has been withheld for 5 months since there was an order, and they didn't in that time do anything to go and get it. I don't like this. I don't like it at all. Part of their argument, depends on that idea that, okay, if this Apple account is information that you have an expectation of privacy in, then a subpoena isn't good enough. They got to get a warrant. And so if they got it by a subpoena, that's a violation of his privacy rights. But if you don't know if he got it by a subpoena because you don't know what the subpoena actually asked for, I don't like that. It seems like an oversight. It should have been followed up on. I definitely do not like filing a motion when you're saying, this motion is based on information that I don't have. You got to make your record. You really got to make your record. So they should have made sure they had that information by the time they filed this motion. So he admitted in this affidavit that the FBI had already subpoenaed the requested information. Give me a second. Excuse me. So unlike the previous one that we saw where he didn't mention that, he just said FBI got the information about his Amazon account, but didn't disclose that prior subpoena. On this one, they did. And then Apple responded to the warrant, provided access to the responsive data. They downloaded it and did a return. Once again, a cut and paste job on the affidavit, not terribly concerning for me. Facts used to support the search, in addition to the general arrest affidavit, knowledge of Apple, method that iCloud uses to create, store, and synchronize data. Give me half a second again. Okay. Identified this full iCloud account under the name of Bryan Kohberger, and another account Wi-Fi Army owns at yahoo.com. And then a subscriber account linked to this northampton.edu with the quote determined from the information produced in the federal grand jury subpoena. So once again, he got it from the subpoena, but he didn't say that specific part. Timing of the account access was around December 20th, when Payne knew Kohberger was in Pennsylvania, still accessing the Apple account with a known iCloud before the homicides and then days before his arrest. This was not real clear to me, but it sounds like they're saying the time of the search. They accessed his account on December 20th of 2022. But this was as searched by Corporal Payne. It must be, my best guess here is that the information produced in the federal grand jury subpoena was one of these kind of bulk data downloads. So he kind of did his own search of that. But it's not very clear. It's not all that specific. And then this right here. This is what raises a massive red flag to me. Corporal Payne requested a very broad time frame of October 7th of 2016 to December 30th of 2022, over 6 years worth of Apple data. That's a really, really broad time frame. That is a really broad time frame. So let's get into the arguments here. Apple, we have a whole same issue with the third-party stuff. It's a corporation, but they hold an awful lot of your data relative to what the phone company or the bank or even your doctor used to hold, because your phone and your iCloud account that incorporates everything on your laptops and stuff as well. That includes all that information, right? Your appointments with your doctor, they're in there. You log into your medical records, your login, records are there. Your password is there. Like all this stuff, it's there. Far beyond what a single corporation would hold in previous eras. Here is everything that they sought. All records or other information regarding the identification, including identifying information about the account owner, information regarding the devices associated with or used, the contents of all emails associated with the account, including stored or preserved copies of emails, the copies of all instant messages associated with the account, including stored or preserved copies of instant messages, the contents of all files and other records stored on iCloud, including all iOS device backups, every single Apple device backup, everything on all your devices for 6 years. All activity, connection, and transactional logs for the account, all records and information regarding locations where the account or devices associated with the account were accessed, 6 years of location data, all records pertaining to the types of service used, all files, keys, or other information necessary to decrypt any data produced in an encrypted form. This is what I would call a dragnet search. This is everything. This is everything. All of his digital data available through Apple. There's no limit to this at all. I can't think of a single thing that you might be able to get through an iCloud account that isn't encompassed in this warrant for a 6-year period. That is so incredibly broad that this is the motion right here. I'm going to think this one has some teeth. This one is going to have some teeth. This is a bridge too far because there's not even an effort to limit it. There's not an effort to limit it to relevance to the particular crime. There's not an attempt to limit it to particular types of information that you have reason to suspect are evidence of a crime. I mean, this is everything. This is just take all of your information and let me look through it. That, I think, is going to be a problem. So now we're going back through the same argument about the kind of third party doctrine, right? And this idea that, well, bank records you can get, phone records you can get, but sell stuff you can't. Sell stuff you really can't because it's different. Corporal Payne specified in his request that the purpose for gathering the information from Apple Inc. was a belief that the Apple accounts would provide information concerning Kohberger's plans, thought process, research, locations, photos, or other pertinent information stored on his Apple account, including his iCloud account. They wanted to fish through everything. There's no indication in any of this that they have proof that any of those things even exist, or that they have reason to believe he did them on Apple devices. This is really, really a massive fishing expedition. And it's literally like they just talked about in the Amazon warrant. This is the type of information that can allow people to get into your mind and to know who you are, how you think, what you believe, what type of person you are, who your friends are, who you don't like, what you're afraid of, what your secrets are. Explicitly saying that's what they want. They want to get all of it to get into his mind. Ooh, boy, is that alarming. To the extent that information gathered included information from an Apple account created in 2016 and an iPad purchased in 2018. Includes all this stuff. It was, in essence, a cell phone search. I mean, it's much broader than a cell phone search. It's a search of the cell phones and all of every other device, every other Apple device. An iPad purchased in 2018. It's the only specific device we know of, but he had the account before that. So what did he have? An iPhone, a MacBook? I mean, who knows? But any backup from that? Oh. And based on what information that anything was going on in 2016 that has to do with the crime? So some of the information that's included in this warrant that he has a privacy interest in already recognized in Idaho that you have an expectation of privacy in whom you dial and the content of text messages that we send. So up here, where they asked for instant messages, emails, these types of logs that would tend to show phone calls and so forth, probably going to be covered under this Idaho law. And so that means you can't get a federal grand jury subpoena. That's not going to be good enough. You got to get a warrant. And so the fact that you already had this information because the feds got it under a lower standard, that's an issue. That's an issue. Because you can't rely on that same information to go try to sanitize it later by getting a warrant. From the standpoint of the Fourth Amendment, the data Apple collects can provide a massive amount of information about a person's private life. Oh, you think? They provide access to email, iMessage, FaceTime, Game Center, location services, information associated with the creation and use of an Apple ID, including basic personal information, user's full name, physical address, telephone numbers, means of payment for Apple products, the date of creating the account, the length of service, records of login times and durations, types of service utilized, status of the account, IP addresses used to register and access the account, connection logs for services like iTunes and App Store, the devices, device identifiers, 5 gigabytes of free electronic space free storage. You can also buy additional storage that might have, your photos, your videos, your documents, your presentations, web browser settings, Wi-Fi network, all of your SMS and MMS, voice messages, call history, contacts, calendar events, reminders, notes, app data, and settings, Apple Watch backups, other data, backups of all of their device, productivity apps. And also, by the way, all of your website login information that you can store. Yeah, they can get all that too. All of it for 6 years with no limitation at all. As for Idaho, once again, no doubt that Article 1, Section 17 requires a warrant before law enforcement can access an Idahoan's online records. I don't know if it's going to matter here. Once again, Bryan Kohberger is not an Idahoan. He's in Washington. But that's going to get us into that conflict of law question and whose law are we even applying here? Does it matter? I don't know. Court's going to have to figure that one out. But to the extent the court might see this as a third-party doctrine issue, the arguments made in Mr. Kohberger's memorandum in support of suppressing Amazon records fully argue that doctrine and are incorporated here. So basically, everything we already talked about with the state of the case law, the inconsistent reasoning in the federal cases, the reasoning that we have in the Idaho cases that would tend to distinguish this type and content of data, this amount of data, those also apply to the Apple account information. The Franks stuff, once again, incorporated. We just have this kind of throwaway line where information in a warrant was obtained via a violation of the Constitution. Idaho courts excise that information. So it's just telling us kind of what the rule is, but it's not identifying something specific. The IGG would have to be excised, and any other illegally obtained information would need to be excised. Okay, here's where we get to that. This is the first instance of that, what I consider a little bit of a technical argument about fails to actually provide a command to search for a particular Apple account or the contents of the iCloud. It orders seizure and it has no time frame. So a warrant is supposed to direct the law enforcement officer who's receiving it to go and seize certain items and then file a return identifying basically what was able to be recovered as a result of that search. This can be an issue in data cases because the nature of what is commanded is not always clear. And so what would happen, for example, would be that police might initially get a warrant to go and seize, say, a cell phone. And they would say, well, because we believe there's likely to be photographs or text communications or something like that inside the phone that is going to, give us evidence of the crime. So they would get a warrant that authorizes them to go seize the phone. But the warrant does not authorize them to then seize the contents of the phone and review and search all of the contents of the phone. So you might have to get a separate warrant if your warrant doesn't actually allow you to do both of those things. And if a police officer is relying on a warrant that says go seize the phone and then, tries to search the phone as a result of that authorization, that's not always going to be allowed. Like that can be a problem. So these are legitimate issues that come up. The command does need to say this. It defines the scope of what your authority is for the search. And so if you exceed that, then the search that you do is not authorized by the warrant. So it says here, generally, the warrant said there are grounds for issuing a warrant and there are grounds to believe the property referred to and sought in or upon said premises consists of information related to crimes on the Apple account of. The command is made to search the premises for the property and seize it. The premises is 1 Apple Park Way, Cupertino, California. So the warrant authorized the seizure of the Apple data from Apple, but it doesn't specifically authorize the searching of that data, the seizure of any particular information inside that data. So this is basically the argument that they're making. So this can be cured. These are technical defects, and courts will bend over backwards to try to find ways to fix them. And the most common one is to say, well, we can read the affidavit and understand what you're getting at, right? And so lots of case law that basically says, look, if there's, if the warrant makes a reference to the fact that it's based on an affidavit, and on the information and request of the affidavit, then we're going to go ahead and let the affidavit control the scope of the search. Their argument here is that that's not really done here because the warrant doesn't refer to the affidavit itself, only to proof. I don't think this is going to fly. The proof is the affidavit. The reason why it's an affidavit is because an affidavit is sworn testimony, and sworn testimony is proof. So I think this is kind of a semantic argument. It's not a bad one. It's one I think that they probably have to make given the ambiguity in that command language, but it's not one that I think is going to win. They just argue the word proof does not specify that the court relied on the affidavit for its probable cause determination, but that was the proof that was submitted in support of the probable cause issue. So I just don't know that this one is likely to be a significant problem. Again, courts will bend over backwards to find ways to read it to say that it's sufficient. So I'll be interested to see what the state's response is to that one. But my suspicion is that, if I'm just knee-jerk reacting to this as the state, without doing my own independent research and so forth, I'm taking issue with this argument right here. The word proof is enough because the proof is referencing the sworn affidavit. That's testimony, and testimony is proof. All right, now the real meat of this Apple warrant. Failed to provide specific particularization of what to search. The United States Supreme Court, when confronting new concerns wrought by digital technology, has been careful not to critically extend existing precedents. Yes, they have struggled with how do we reconcile the analog era and the digital one, and the law that we created using these analog frameworks don't necessarily translate well into this new digital era. So what are we going to do about that? Courts have so first off, a warrant is not a magical wand that grants access to anything an Apple account contains. Well, I certainly hope not, but that appears to be the legal question before the court. Is it a magic wand that grants access to anything an Apple account obtains or not? Because that's certainly how the police used it. Courts have long required that warrants be sufficiently particular to allow a government agent to know what may be seized, viewed, or searched, and what may not. In striking a balance between law enforcement interests and the right of individuals to be free from unreasonable searches and seizures, the process of segregating electronic datable that is seizable from that which is not this is a bad quote. I'm not sure exactly where the grammar went wrong, but it may not become a vehicle for the government to gain access to data which it has not probable cause to collect. This is this Ninth Circuit case comprehensive drug testing. There must be some threshold showing before the government may seize the haystack to look for the needle. The data compilation requested in the Apple warrant is too broad in that it makes no attempt at narrowing and results instead in a blanket request for everything available in 2 Apple accounts with iCloud, which is akin to the search of all electronic records, an entire computer, or all data on a cell phone. It is a request for the full haystack without any temporal restrictions. Yeah, it is. It's a request for everything. Jurisdictions across the nation agree that such broad warrants are problematic, but found that trying to fix that issue via more particularized warrants has its own issues. It would have been nice to have that spelled out a little bit more specifically what she means, because, yeah, broad warrants are definitely problematic, and there are plenty of cases that strike down overbroad searches of cell phones, these dragnet searches of the entire contents of a cell phone or something like that. But I don't know what she means by trying to fix that issue via more particularized warrants has its own issues. I don't know what that means. Still, this case presents a warrant that is overbroad under longstanding principles. First, as far as particularity goes, the requirements of probable cause and particularity serve different purposes. They are, but they're also related. So you're not supposed to have searches, any search that isn't based on probable cause to believe that the crime has been committed and that evidence is likely to be found in the area to be searched. But the second objective is that those searches deemed necessary should be as limited as possible. Here, the specific evil is the general warrant abhorred by the colonists. That just come in and trash your house and look for anything. Look for anything at all. And the problem is not that of intrusion per se, but of a general exploratory rummaging in a person's belongings. Yeah. That's the problem. So you got to be specific about what you're looking for. And that is particularly important because it's got to show a nexus for why you think it is some evidence of criminal activity. How does it help you build your case as opposed to just being a fishing expedition to go through and look and see what you can find? Like that's where the issue is with all of this. If you want his location data for the night of the crime, you can ask for that. That's very specific, very likely to give you the information that you're looking for as far as proof that he was there or not there. Communications about the crime, that's limited. Planning, proof of planning, internet searches or whatever relating to planning the crime, that would be limited. But there's nothing like that in any of this. It's just give me all the data. If the police, upon obtaining entry to a house under a search warrant, were permitted to seize any item, regardless of its connection with crime, and regardless of whether they knew the item was on the premises, the requirement that a warrant particularly describe the items to be seized and that only items for which probable cause exists be seized would be meaningless. In effect, a warrant to enter the premises to search would be a general warrant in actual execution, if not in form. Yeah. If they aren't required to narrow it down, and if they're just allowed to be like, well, there's probably some evidence on the phone, so give us the entire contents of the phone, that's a general warrant. That's saying we think this colonist is probably involved in some kind of treachery. So let's go through all of his house and all of his papers and all of his belongings and see if we can find something that looks bad. So I want to talk briefly about this case that she mentions, this U.S. comprehensive drug testing, because it did. It had this. This is a case I've relied on before, and it's a case that anticipated this whole problem. This pressing need of law enforcement for broad authorization to examine electronic records, so persuasively demonstrated in the introduction to the original warrant in this case, creates a serious risk that every warrant for electronic information will become, in effect, a general warrant, rendering the Fourth Amendment irrelevant. This concern grew in the aftermath of Riley. Riley is what requires police to get a warrant before they can look in your cell phone, before they can search your phone records. Of course, Riley requires that the officers first get a warrant, but if the fact that the arrestee was carrying a cell phone at the time of arrest is sufficient to support probable cause for a search, then the warrant requirement is merely a paperwork requirement. It cannot be that Riley's holding is so hollow. This is getting at that nexus that you have to have with the probable cause of a crime. You have to have reason to think there's evidence there. And you got to be a little bit more specific than, well, just phones have lots of stuff in them that can give us lots of information about people. And so the whole purpose of the warrant is to require the state to clarify, to narrow down what is it that we think is there, and how is that going to tie in to being proof of the crime. Location at the time, communications, planning it, preparing it with co-defendants, with, accomplices, things like that. They let you narrow the scope of a warrant for digital information. So then she relies on this Idaho case that you cannot just get into a computer and ask for records that will be seized and used of evidence of the crimes. That's literally saying a fishing expedition. This is a warrant for a fishing expedition. Anything that you find that you want to use, you can. That is definitely, from my perspective, turning the warrant into just a paperwork formality. It doesn't have any meaningful protection of the privacy rights of the person that's being searched. So in that case, two problems with that warrant. It left to the discretion of the investigator what was relevant to the crimes alleged. That is always a little bit of an issue. And second, it made no attempt to delineate the types of files that could be relevant to what the police believed they would find in that particular case. Specifically, evidence that the defendant had made an online search of his alleged victim's address. In those circumstances, there was no reason to go looking at videos and pictures. Yeah, that's how you narrow it. What exactly are you looking for and expecting to find? So they create this kind of analytical framework where warrants have to be specific both as to the where that is going to be searched, what they're calling the category, meaning like the phone, the computer, things like that, and also what is going to be searched within that item, so the specific file sought. And you have to be clear as to both of those things. And if you can name them with more specificity, then you really need to be able to do that. Here, they were capable of that, but instead they just said, give us everything. Give us everything that he has created in Apple for over 6 years. Another case coming out of Delaware, similar one, overbroad digital warrant, where the information kind of explains what it is that they're looking for, but they got a full warrant to get data, So the warrant itself didn't respect the limitations that they had put forth in the affidavit as far as their general basis for getting in there in the first place. We hesitate to prescribe rigid rules. Yeah, this is the hard thing that they're dealing with in the digital era because these things are changing very quickly. This is a new frontier and we're still just at the very beginning of what all of this is going to mean. So they don't want to prescribe rigid rules. Instead, reiterate that warrants must designate the things to be searched and seized as particularly as possible. Striking the correct balance when protecting against generality and overbreadth requires vigilance on the part of judicial officers who are on the front lines of preserving constitutional rights while assisting government officials in the legitimate pursuit of prosecuting criminal activity. Well, wouldn't that be nice if judges actually acted as gatekeepers for this type of thing instead of merely rubber stamps? It happens once in a blue moon that a judge will decline to sign a search warrant, but it's pretty hard. Doesn't happen that often. Takes a lot. You got to be pretty far over the line for the judge to say, you know what? Can't do it. Gonna have to fix this up and bring it back to me. And then what happens a lot of the time anyway, they just go to a different judge. Yeah, judges should be gatekeepers of this type of thing. But as we see over and over, they are not. They just rubber stamp whatever is put in front of them. Whereas here, the investigators had available to them a more precise description of the alleged criminal activity that is the subject of the warrant. Such information should be included in the instrument, and the search and seizure should be appropriately narrowed to the relevant time period so as to mitigate the potential for unconstitutional exploratory rummaging. Yeah. Not just whatever there might be there over a 6-year period. In the case at bar, the government is investigating a quadruple homicide in Idaho. Does it make sense to see if there is some hint at wanting to fight someone from 2 years prior, 5 years, 10? What of everything else that may be relevant to what the police knew? The contents of his phone, computers, K-bar sheath, and the Elantra, for that matter, what of the victims themselves, their sororities and fraternities? The warrant could have specified what was to be searched, seized and searched, but it did not. And that's ultimately the problem. They said, give us everything. Let us decide what matters and what doesn't. This, guys, is a very strong warrant. This is a very strong motion. This overbreadth motion, my opinion, very strong. It just has gone way too far. It's way too far. Everything for 6 years from Apple. Okay, I want to also take this opportunity with this particular warrant to address the whole idea that, oh, there must be bad stuff that the state got as a result of this investigation. It must make Bryan Kohberger look really guilty because that's why he's moving to suppress it. This warrant should make it clear that what they got was everything. Okay, what they got was everything. And when they get everything, there's really very little limit on their ability to take things out of context or to paint them in a way that look really nefarious. 6 years worth of data. This guy has been in graduate school in criminal justice. What kind of searches you think he's done? Think they might be able to find some, weird looking stuff in there? Criminally minded stuff? It doesn't have to be proof that he committed the crime for them to get it and use against him at trial. They can always rely on the time-honored tactic of the smear. Just try to make him look as bad as possible. In the absence of a connection between him and any of the victims in this case, well, why don't we go back to maybe old SMS messages where he was fighting with an old girlfriend and maybe said something not very nice to her, right? Prove some type of, misogynistic attitude. That's the kind of thing that weak cases are built on. If they don't have the actual goods, then yeah, you better believe they'll go with the smear. So that's why you move to suppress all this stuff, even if it's meaningless, as far as being, you know, meaningful, significant evidence of guilt of this particular crime. It doesn't show his location. It doesn't show planning. It doesn't show contacts. May not show any of that, but if it can make him look bad, they'll use it. So that's why you move to suppress it. Particularly when you have something just as overwhelmingly comprehensive as 6 years worth of Apple data. It's wild, unbelievable. So the Apple warrant is one that I think has quite a good chance. Quite a good chance. Now, Judge Hippler going to grant it? I don't know. This is maybe going to be for me a little bit of a test run of Judge Hippler, because from an appellate standpoint, this is strong. So I'll just be interested to see what his approach is. Very interested to see the state's response on this one. They're going to have to try to argue it's particularized. I don't know how they're going to get there. Well, it's particularized because it's just his Apple account, and it's not, every bit of digital data under the sun. Well, the problem is they got other warrants for that too, as we'll go ahead and get to. But, the existence of other stuff in the universe doesn't mean that your request in this context is not a problem. So I'm going to expect the state to have some pretty good precedent that's upholding a warrant as broad as this, or I think they're going to have a real problem. All right. Moving on. The arrest warrant. This one largely just incorporates arguments that we've already heard. We've got the conflict of law issue. We've got the Franks issue. We've got stuff must be excised because of IGG and the invalid warrant. But once again, we have some facts that are a little bit interesting here. The haphazard way in which law enforcement, including the prosecutor's office, has kept and disclosed records in this matter. They did the data dump, right? Make the defense sort it all out. The following is a rough statement of facts as best as the defense can tell. So December 28th is when they became aware. We saw this before. The objective of arresting him in Pennsylvania. 4:44 p.m., the magistrate issued a search warrant for the parents' home. The magistrate in Idaho, in Latah County, signed a warrant for Mr. Kohberger's arrest. They filed the probable cause order and the complaint, and then at 10 p.m. Eastern, they began their preparations. Even though they had him under surveillance, they decided that they would enter into the home. On December 30th at 1:14 a.m. Eastern, Pennsylvania SWAT raided Mr. Kohberger's parents' home. During the raid, law enforcement broke the door of the home, held the entire family at gunpoint, and seized Mr. Kohberger. That's how these things go. Mr. Kohberger made statements to his arresting officers. Interesting. Don't know what they are. Maybe we will find out. He was transported to a police station in Stroudsburg, Pennsylvania, and made statements during transport. At the station, Mr. Kohberger was processed, during which police collected information about his person. This is typical booking information, but they can often get a lot of other kind of information about you through that. And finally, during interrogation, before requesting an attorney, Mr. Kohberger made statements to interrogators from the Idaho State Police and the Moscow Police Department. So the reason why I highlighted these particular ones is because this always comes up when somebody is initially arrested if they aren't immediately Mirandized, if they aren't immediately read their Miranda warnings, because that's one of the requirements you have if you're going to subject somebody to a custodial interrogation, which means they're in your custody, which they are. He's been arrested. And you are going to ask him, you're going to say anything to him that's intended to elicit an incriminating statement from him. That's what an interrogation is in this context. That's always going to be at issue. You have to read Miranda before you can do that. But then there always ends up being all this gray area around the edges because, if they don't read him his Miranda rights, question still comes up, is he being interrogated? So are you asking him things meant to incriminate himself or just to identify himself or just like meaningless chit chat? Or did he volunteer this stuff seemingly out of the blue? These are where these things always get a little bit fuzzy. But what it makes clear from this is that it seems they did not Mirandize him at this early point in time. So first we have this issue with the choice of law. Once again, we have this issue with the Franks. Once again, we have this issue with the IGG and anything else that's invalid. Once again. So not a whole lot here. Just kind of from a legal standpoint. As far as the basic issues here, they do specifically call out the AT&T trap and trace that needs to be excised. But then the only other issue that we have in this one that they're calling out here when they're talking about the choice of law, the reason why it matters. Pennsylvania courts require a warrant for a particular residence to go after a person police are aware has an arrest warrant. The need for a warrant for a fugitive from another state is codified. So basically what this means is that they have a problem with the extraterritorial jurisdiction in Pennsylvania to enforce the Idaho arrest warrant. States are separate sovereigns. They don't necessarily have to recognize the acts of other states like that. And so this is very common when you're dealing with an out-of-state arrest or an arrest on an out-of-state warrant and then a subsequent extradition. There may be some type of process that needs to be gone through in the state where the person is going to be arrested in order to give them the authority to enforce that out-of-state warrant. And so Pennsylvania does this with a governor's warrant. So here they say you need either a fugitive warrant or a judicial warrant to permit entry into a home. If you don't have either of them, then the officer doesn't have the authority to go in and arrest the person. So basically they're arguing law enforcement in Pennsylvania could not rely on the existence of the Idaho arrest warrant to enter the home. There's this kind of footnote here that says basically there seems to be a little bit of conflict in Idaho law on this issue. But whatever one we apply, if they fail to knock and announce, that's a problem in both states. That's kind of interesting. That doesn't undermine the arrest warrant itself, but that will come up in one of the subsequent motions where the warrant was like dealing with the execution of the warrant. So regardless of which state we look at, they weren't supposed to rely on the Idaho arrest warrant to enter the home. Well, the problem is they did get a search warrant for his house, right? The law here seems to say that you either need the warrant for the arrest or a warrant to permit entry into the home. They did get a search warrant for the home, right? We saw that in the previous motion, and it's the subject of a separate motion to suppress. So I don't know that that one is in and of itself going to go anywhere. Seems to me that the arrest warrant from Idaho is going to stand or fall on its own merit in terms of these IGG and Frank's issues, which are really the main ones that are argued on is like invalidating that particular warrant. Next up, the AT&T first warrant. Same things that we're still dealing with, phone records. We've already established U.S. Supreme Court doesn't necessarily recognize a privacy interest in them, but Idaho does. So to the extent that any of those records were obtained without a warrant, that is potentially a problem. The Franks issue, overbreadth is another allegation here. And then same thing as far as IGG requires it to be excised. So now this is the December 23rd, 2023 request. So now we know for sure the day before was when the FBI sent the preservation letter to Apple, December 23rd. Now we have Corporal Payne requesting a warrant to search for the contents of his AT&T account for information regarding his phone's whereabouts between November 12th, 2023 and November 14th, 2023, as well as messages and phone calls during that period. Much more limited time frame that we're dealing with here than we were dealing with in the Apple warrant. So we at least have some type of tailoring here. But here's what they requested. All of the customer subscriber information, identifying information, device information, activation, deactivation date, point of purchase, device purchase information, any email addresses associated with the account, call detail records. This is when they were starting to try to get those, the CSLI data, right? This is what they were trying to use to trace the phone and compare it to the video canvas for the white cars that they were looking for. So the CDRs associated in reference to all known outgoing and incoming calls associated with the account, dates and times calls were made, and the duration of all calls made or received. Now, this is a bit curious, right? Because on the one hand, we have this time limitation, but then we have these requests that appear to be quite a bit broader than that. So it's not really clear from how this is written how particularized the actual request ended up being. So more CDR information associated with the tower records, as well as text messages, MMS messages, data activity, anything included there. The cell site provider information, location information, all this transmission information. Location information can be in the form of historical records. This would include any reports of device activity that would include the approximate latitude and longitude of the device at the time of the activity. So all of this other specific, location type of data. All text message and or MMS messages, including message content currently stored in the normal course of business for the service provider, to include any cloud services which allow for the long-term storage of both voicemails and SMS or MMS messages. this once again, is that temporally limited? And then cloud data, any content that may have been backed up to cloud storage for the listed dates or times. If cloud storage has been provided by a third-party provider, provide relevant contact information. So the defense, seems to be a little bit confused by this as well, because they say they only want the records between November and November 12th and November 14th, but they also want, quote, prospective phone records. This might be anticipating the trap and trace, but it just really isn't particularly clear. And the problem with that is because there is a separate warrant for the pen trap and trace, so shouldn't really be included in this one. The issue that we're going to have in this warrant, I think, is going to be limited to the communications. They wanted all of this information, but they wanted it, related to a pretty limited time period. And it does seem to be pretty clear why they would want this information, why it would be relevant to their investigation, because if it's his, account that's associated, his phone number, they want to know, does he have accomplices? When and where is this a new phone? Like, is this a burner phone? Has he had this phone a long time? That's going to give us a better idea of, like, is there other information that we may develop to justify, getting more information from this phone or from these accounts? Same thing with the email addresses, the CDRs and everything, the CSLI, the historic location information. This is all directly relevant to the location stuff that they're looking for. So in and of itself, I don't necessarily see those things being particularly problematic, because they are specifically called out and they are limited in the time frame. But the text messages and data activity and cloud data, these are potentially bigger problems, because I don't know why at this point, if we have an argument that we think he was there, okay, but what's your argument for who or what he was talking to? That seems pretty speculative. From what we know, or what we can piece together at this point in time, what we can infer is, okay, the IgG on that DNA that was found on the knife sheath, that has now gone through the process, and that has targeted Bryan Kohberger. He is the one whose DNA is on that knife sheath, according to that results. So that's why they're now looking at him, and they have his phone number from that previous stop, that ticket that he got back in August. So they have his phone number, and that's what they're following up on to start to get this information. But they don't know anything else at this point in time. So they don't have a basis to think that he communicated with anyone. We don't have a reason to think he was a solo, that he was a solo perpetrator, or that he had accomplices. We don't have a reason to think that he knew the victims or didn't. We're just at this very, very initial stage at this point. So this is where I think there might be a little bit of an issue with this particular warrant. Not the entire thing, because I think the some of what they asked for is, does seem to be pretty legitimate. But I'm not necessarily convinced they had a basis to be looking for messages at this point in time. And the whole purpose here is to aid in determining the location of the phone. And they're, trying to, again, use that to build that map where they tie in the location of the phone to the location of the Elantra. So we're at the very beginning part of piecing together, is Bryan Kohberger, even Can we even like connect him? It's well before we get to any sort of argument about how did he do it, why would he have done it, and so forth. So, little bit, given the fact that Idaho has already said, yeah, contents of your texts and things like that, those are subject to, you have a reasonable expectation of privacy, then you need to have probable cause to support seizing those. I'm not sure I see it from their justification. Otherwise, for this particular warrant, we just have the Franks issue. We have an argument that this one also is overbroad. That's pretty much what we've just been talking about here. I don't think this is necessarily, a strong argument. But again, it just kind of depends, because it seems that the warrant was written in a very ambiguous way, where on the one hand, they're asking for this very comprehensive information that doesn't seem to be limited by time. But then they are also, including language that says it's limited to the particular time frame. If it's limited to the time frame, then we're closer. But if we're not limited to the time frame, then we got a much bigger problem. Because now we're just, we're back into this area of kind of general searching all of your call records, everybody that you called, all of your text messages, all of your data activity, whatever that can consist of, the searches that you do over the phone, your maps, all those things that you run through a data network. That's all pretty comprehensive. Any data now in the cloud, that one's probably going to be an issue whether from my perspective, whether you're limiting it to November 12th to November 14th or not. Just because, any data in the cloud is far, far, far broader than the location data you said you're trying to get. So I think this one is just going to kind of come down to what's the reasonable interpretation of what it meant. And part of that is going to be based on what did they actually get? Did what they get end up being limited to the November 12th to November 14th timeframe? Or was it broader? If what they actually got was broader, then I think that's going to, suggest there's more of a problem here, because it suggests that's a reasonable interpretation of the way that they wrote it. And so they didn't write it in a way that, allowed it to be particularized. In the alternative, if it was intended to be limited, right? If we could say, well, just reading it, the plain language, how we interpret the language, the limitation would apply to all of these broader categories, but they actually got more, then you have a problem with overbreadth in the execution. So potentially a problem there. I don't think this one is quite as strong as the Apple warrant, but I do think that there are some issues here, because in particular of that additional protection for the text and the phone communications and stuff. And so in the absence of some type of indication that text or phone messages contain evidence of the crime, I don't know how you get there. So they've got several other warrant cases from different states involving cell phone searches. So they've kind of spread some of their analysis around a little bit of some of the different briefs. But I do like how they rely very heavily on out of state jurisprudence. Sometimes it's all you have. The problem is that these issues start to happen, and often when you have agencies like the FBI involved, the FBI will operate in all the different states. The FBI has their own practices and way of doing things, and their own customs and so forth. And so they can do things that haven't been tested in the state where they're doing them. And it can be kind of common. So lots of states then will deal with a new technique or a new approach, or like the specific language that this particular agent has used in warrants all over, the Western states or something like that. And it doesn't necessarily hit your state, early. You might be the last one in line, but all the other states ahead of you have already dealt with this. This can be complicated, and it can have some limited utility for a lot of reasons. Number one, it's not binding precedent. What other states do isn't binding on Idaho, but it can be persuasive. The problem is the persuasive value that it has can be very limited because of the different constitutional frameworks. So if, for example, we're relying on a Michigan case here, I don't know, from this analysis here, whether we're talking about a Fourth Amendment issue, whether we're talking about a Michigan constitutional issue, an independent one. I don't know whether those are coextensive. I don't know whether Michigan is more protective. If Michigan is more protective, I don't know if it's more protective in a way that's similar to Idaho being more protective or not. So these are always a little bit of a pitfall when you're dealing with warrants, or when you're dealing with case law from other jurisdictions. But it is good to do it, because sometimes that's all you got with these cutting edge, issues. Look at these. It's from 2022, from 2024. These are things that are materializing, as we speak. 2023. So it's good to give the court the lay of the land, at least put it in some kind of context of what the state of the law is nationally. They may or may not agree with it. They may or may not go along with it. They may find reasons why Idaho is different. But I think it is important, particularly in this context, to be able to show. This isn't the first time a question like this has landed in the court. Everything else that we're dealing with in this particular warrant is just the same. The IGG argues needs to be excised. Without IGG, no case, no request for his phone record, surveillance, etc. Moving on. We should get through the rest of these pretty quickly now, because most of them at this point are just going to be repetitive of things that we've already talked about. So the cell phone USB file and memo in support. So what they did in this particular issue is they seized his cell phone when they arrested him at the house, and then made a copy of the contents onto this external USB drive. And so then Detective Mowry got the warrant to search the contents of the USB drive that contains all of the contents of the cell phone. So, arguing just the timing and that the data on the phone had already been extracted by the FBI. Not clear to me if, again, it's just unfortunate kind of lack of clarity with the language. Is this what we're talking about by the extraction? Made a copy of the contents on the cell phone? Or are we talking about something else? Because it's additional facts. Did they also do a Cellebrite extraction or something like that on the phone? And if so, did they get information from that? And if so, did they communicate that information to Moscow law enforcement? Because I can't help but notice we got quite a gap here, right? December 30th to January 9th. I would think the phone would be one of those things that you would want to get into ASAP. Like, they were trying to backdoor their way in 10 days earlier, with the AT&T records. So that's a little bit factually ambiguous to me, and it's unfortunate. I would like that to be clarified, but unfortunately it's not. So for this one, we have the Franks issue. We have the IGG issue. We have the other warrants. Anything else that's unlawful needs to be suppressed. And then the fail to command issue. So this one, the USB drive contains evidence regarding the investigation, and then lists possibly all possible types of data on the drive located in the MPD's forensic lab. Command is made to search the premises defined as the police station's forensic lab for the property and seize it. So once again, we're at a situation where you're getting authority to seize the thumb drive, but not necessarily to look in the thumb drive. You're not necessarily getting the authority to go into the data that the thumb drive contains. And that's the step, that you need to take, because that's really what's of interest. The thumb drive itself is not. It's the data on it that you want. So once again, the problem here, it's the same thing. The affidavit says one thing. There's no reference to the affidavit, but only to proof. I think proof is going to be construed as being the affidavit. So I think this failure to specifically command is probably going to fail. They're going to be able to look at the affidavit and say, well, we understand that the seizure was meant to really be the data in the thumb drive, in the USB drive, and so that's okay. Then once again, we have an overbreadth argument, and this one is just basically going to the fact that the USB drive itself contains all the contents of the cell phone. So if you have to particularize the contents of the cell phone, you would have to particularize the contents of this thumb drive as well. You don't get to get access to more information on the thumb drive just because, they've taken this step of already pulling it off the phone. So you need to go through the same type of particularization with the thumb drive as you have to do with the cell phone. So this one has a little bit more limiting language to it. This one I found a little bit strange. Data compilations relating to or containing information indicating, suggesting, or related to violence, a fight, or motive, hostility for any of the same. Strange. I don't know what that means. Like a fight between specific people? Or are we looking at propensity for violence types of things? It's kind of confusing. If they were looking for evidence that Bryan Kohberger knew the victims and fought with them, and that was the motive for committing the murders, okay, that would be one thing. But it doesn't say that. It doesn't really specify any of that at all. And so the problem is that as I read this, this would cover watching the boxing, bought the pay-per-view for Paul, or I guess it wasn't on pay-per-view, the Netflix, the Mike Tyson and Jake Paul, a fight. Do you watch MMA? Watch UFC? It just seems a little bit strange to me. But then, including that basically the limitation on all of the documentation that they want to search for in the phone, but then unlimited records of communications, emails, SMS, MMS, third-party applications, all the contacts, the location information stored in any cloud account associated with the phone, if you can get it from the forensic image of the phone, internet history, bookmarks, written and audio recorded notes, indicia of residency in or ownership or possession of the premises, and any of the above items. So where I think we have the potential to have overbreadth problems here, internet history, all of this location information, contacts, all of your contacts, all of your communications. These things are problematic because they're just far more than what you would need to investigate. Did he have communications with these victims? Did he have communications with, accomplices? Like, that can be narrowed. It could be narrowed. If you want written or text communications that tend to show planning, preparation, motive, etc., you could narrow it that way. But they haven't done that. They've just said all of it. So once again, getting into the phone, I think this kind of is. I think this kind of is a problem with being overbroad. So just basically going through, what we've already seen as far as the particularity requirements for the warrant, that argument for overbreadth, all of these other cases where digital warrants have been analyzed. Look at this long list of cases where warrants have been found overbroad for lacking the temporal limitations. Okay, this is quite a list of string cites. Okay. And some of them are real important here. Ninth Circuit from 95. Yeah, that's pretty important because the Ninth Circuit is the district that this case will be heard in if it goes up on federal review. So yeah, that's going to be pretty important binding precedent in a federal habeas type of process. Look at that. Also one from Oregon. So seem to have a lot of law supporting this idea that, yeah, cell phone searches, you need to be specific about what it is that you're looking for. You don't get to just ask for everything across all times. Now, they are asking for everything found in the search of the USB drive to be suppressed. I don't think they're likely to get that. I think the stuff that is reasonably limited is probably okay. But the problem is that might just be this indicia of ownership and stuff about a fight. Stuff about a fight. Not sure there's probable cause to support it, but that's just a whole separate issue. I guess they're not really specifically challenging that. But all the rest of it, I tend to agree. This is on very thin ice because they just asked for so much. They put so few restrictions on what they were going to be able to go through. Google warrants. Google warrants here are basically just going to be a rehash of the issues that were the same problem with the Apple. This is just his Android data. He's apparently had Apple devices. He's had Android devices. And so a whole other source of cloud data for them to go and get. So for this one, the facts are just that we got warrants for Google account in connection with this Gmail account, then 2 phone numbers and an IMEI number, then another email account. But they say no specific nexus is mentioned in the second warrant for the new email account other than it was identified. So we've got to wonder about that. Is this an email account that they got from one of these other warrants, one of these other returns that they're challenging? Say, for example, the Apple, right? The Apple data was supposed to give them all the associated email accounts. Was this one of them? Maybe. I don't know. February 24th, Mr. Mowry, Detective Mowry, got the third warrant, just his name. And then there's this other email address, but there's no nexus between him and that email address. There's been a lot of typos in these last pleadings, and it is a little bit annoying. But so it makes it unclear: is this a Gmail or is this a DeSales? And I know DeSales itself is also misspelled, but it's the DeSales down here, and then this username you can kind of read here, but it's misspelled up here. It's all a little bit of a mess. But anyway, they got all of these different addresses. They didn't clarify where they got the names, from, or how they got a link between those names and Bryan. So that's going to the challenge that, you got to have probable cause to think that these email accounts are associated with the crime. When you're challenging warrants, by the way, one of the principles of that is that you don't get to, you're stuck with what's in the warrant affidavit. The police can't come back and say, oh, well, we had this other information that justified that. We actually knew, here's why we knew he was connected, or that this account belonged to him. They don't get to do that because the whole reason is that you're supposed to put all that in the affidavit, because that's what the magistrate needs to rely on to decide if there's probable cause or not. So the scope of your authority is defined by what you put in that affidavit. So you don't get to go back after the fact and add in reasons why, it should have been correct anyway. You're stuck with what you put in this affidavit. And that's why they're pointing out they didn't say anything about these connections, and so that can be a problem. If we don't know why we're looking at this username, email account, we don't know whether we have probable cause to believe that there's reason to think that it could be associated with a crime. And so where did they, we don't know, where did they get that email? Did they get it from the Apple records? Did they find it in one of the devices? Did he buy a used device that had like some old historic record of the original owner or something in it? I mean, these types of things would be possible. So that's why they really need to spell it out. Where did you get this information, and what leads you to think it has to do with Mr. Kohberger? They point out that they got these two email accounts, but nothing about this DeSales account. And they say this is particularly noteworthy because email communication between Mowry and Google on January 4th, 2020, I think this means 2023, references Google not producing data on non-personal accounts. ed.desales.edu, Mowry indicates they, DeSales, are going to be able to help us with their end of the process, so that should be taken care of. Yet they still ended up putting it into a warrant. So I don't really know what the significance of that is, or why it matters. If it turns out they weren't able to get it from DeSales, then it seems like they would be able to get it from Google, as long as Google has got it and is willing to provide it. So it's not clear to me on its face why this is necessarily problematic or being included here. Maybe they will tell us more about that in the argument on these motions. So once again, the cut and paste. The basic facts are about the same. Here's what we know about Google. So some more facts. Kohberger was observed entering a CVS in Pennsylvania on December 16th, 2022, and his email account, Bryan Christopher 1994 at Gmail, and phone number was, quote, somehow obtained by law enforcement. Well, they went and got it from the CVS. They walked up to the counter and said, hey, CVS, we do all that nice loss prevention for you guys. When you have an issue with somebody stealing your stuff, do us a solid here and show us the receipt of the guy that just came in. For Google Warrant 2, a new email is referenced as having been found, and that's this in the Google Warrant 1 data return, this username account. Once again, we don't really know what the context of that is, okay? But I guess we know that they got it from the first Google warrant. A high probability a VPN was identified in Google return. Okay. Google Warrant 3, we now have the details incorporated without any supporting explanation. So for this one now, we're relying once again on the Frank's argument. We're relying on the IgG and anything else. We're relying once again on this fail to command. That's the same basic problem where it says proof. And the question is going to be, does proof mean the affidavit? And I think they will say that it does. And then an overbreadth argument, once again, have to be sufficiently particularized. This is where the problems are with these warrants. When it says comprehensive lifetime data for this account that has no type of temporal restriction or anything like that whatsoever, look at this. Like this is your life. This is your life in here. Who you are, your activity, your connected devices, your Gmails, all of your payments that you use through Google Pay, your calendar, your contacts, all of your photos, videos, anything you store in Drive, anything you do in Keep with your notes, any chats through messages, all of your location data, all of your web browsing activity, your Google searches, Google Lens. I use Google Lens a fair amount. Like if I can't identify something. When I was in Indiana, I was on a bunch of hikes. And I kept seeing these things that I knew what it was. They're just like this gross, brainy looking fruit thing on the ground. And I knew what it was, but I just couldn't remember the name of it. So I had to photo it and do a Google Lens to remind me, okay, that's the Osage orange. This is really weird looking old fruit thing. You don't eat it. But anyway, so I do that a lot. They would find a ton of that on my phone. God forbid I, look to identify something strange. Your Google Voice information, everything associated with YouTube, all of your Android devices, the hardware, Google Play, all of your downloads, your purchases, etc. A lot of stuff here. This is pretty much your life on your phone that's available through a Google. Once again, makes no attempt at narrowing and results instead in a blanket request for everything available in a Google account, which is akin to the search of all electronic records in an entire computer or all data on a cell phone. It is a request for the full haystack. It is. It is. No temporal limitation on that. It's just give us everything. And it's a problem. They just said, give us everything in the Google accounts. So that is the gist of the Google warrant. Nothing legally new that we haven't already seen, but that little additional information about the CVS, little CVS visit, and somehow law enforcement got his email account from that, which suggests that probably CVS handed over the transaction, some of the transaction data. Next up, the pin, trap, and trace. Okay, so first off, just again, some lingo. Pin, trap, and trace is dealing with recording your incoming and outgoing communications. So the trap is when they trap what is coming into your phone. The trace is when they keep track of what's going out. So this is basically, a way for them to, listen in on your phone. So facts for this one, December 23rd, we already know that we're looking for the AT&T account. The IgG has come down. We've targeted Mr. Kohberger, and they're starting to look at his phone number. And now they go specifically to his AT&T account for location information regarding the whereabouts between those dates, as well as messages and phone calls during that period. After the warrant was granted, law enforcement received the information from AT&T. This new information that they received is included in the affidavit for a new warrant sought for both account information as well as a pin trap for Mr. Kohberger's phone. So basically, did the original AT&T warrant, and then based on what they got from that warrant, asked for this trap and trace. So additional facts. Cell records didn't show he was there, but they typically turn off their phones. No, they do not. Analysis of the CSLI showed that approximately 2:42 he was in Pullman, and then he left his apartment and went south. Then the phone was off. Then at 4:48, the phone is south of Moscow. It all supports this, and then coincides with the Elantra. So once again, I mean, what's our nexus to using the phone? Do we have one? Do we have one? So the records that's at issue here, this, it looks like they kind of cut and paste from the original AT&T account information. I don't know that this was necessary to do that because this is the excision argument that's brought up at the end. If you're already going to excise what they got from the AT&T data, then the AT&T account information, you've already filed a motion to suppress on that. You don't need to refile it here. You can just say if they granted it, then it would apply to this one. So this looks like it might be a little bit of a cut and paste job that wasn't necessarily like applicable to this particular search. Because then we got the Franks. We have the overbreadth issue. Okay, once again. But we're still just dealing with the AT&T account data. So we're not dealing with the pin, trap, and trace part of it at any point in this warrant. It seems like we're just reiterating for the same reasons you shouldn't have gotten the warrant the first time. You also shouldn't get the warrant, the second time. It's essentially an equivalent request for information. I am led to assume. And so that's why this is essentially just a duplicate, memo for the original AT&T account warrant. Includes information that must be excised, the IGG, and stuff from other records. But now when they're asking, suppress all evidence obtained by police via the warrant that permitted him to place a trace on his phone. That's going to have to be just based on the Franks and those other similar issues, the IGG, because they didn't provide a specific other reason to not allow the trace. So similar with the data as the first account warrant, but nothing really additional as far as the trap and trace goes. I kind of would think, we'd be looking at a probable cause argument there. Like, why are we looking at his communications? I mean, you need to establish something. I don't know. So a little bit ambiguous there. I'm kind of left to wonder, was this one maybe just rushed? I don't know. I don't want to make assumptions, but it's hard to read between the lines sometimes with some of these arguments. We are 10 down, guys. Just a few more to go, and they should be pretty fast here. So the search warrant for his person, once he was brought into the Latah County Jail. And this is all just based on, they arrested him based on the arrest warrant. The arrest warrant is based on the information provided by Payne. We think that there are issues with the Franks and with the IGG. And so to the extent that they were only able to search him in the Latah County Jail, and through that get the search of his person, pictures of his body, his fingerprints, and a DNA swab taken. Those are all fruit of the poisonous arrest warrant that they're, arguing should not have been granted or had the information omitted from it. The Pennsylvania search warrant for Mr. Kohberger's person. Okay, remember, this is where the previous challenge to the arrest warrant said in Pennsylvania, you have to either get a governor's warrant or a warrant to search the parent's home. Well, we've heard of all three now. Okay, so this is a Pennsylvania search warrant for Mr. Kohberger's person. And now we've seen, in addition, we had the 444 warrant for search of their parents' home. Now 4:45 p.m. warrant for the search of his person. And then, yes, we know they went and arrested him. They decided to do it in the home, even though he might have left and they could have done it, outside of the home in a safer type of situation, but probably less easily controlled, et cetera, et cetera. We have the conflict of law situation. Don't know which ones apply. Frank's issue. IGG issue. And that's basically it. Saying shouldn't have issued the warrant to search his person because of those general issues that are problematic, according to the defense, for all of these different motions. Pennsylvania search warrant for the white Hyundai Elantra. This is where we get some interesting facts. So, December 28th, they knew they were going to arrest him. 444, yet another search warrant from Pennsylvania, search warrant for his vehicle. So now we have, from Pennsylvania, warrant to search the house, warrant to search his person, warrant to search his vehicle. And then once again, we know the circumstances of the arrest. But now we know December 30th, 2022, Pennsylvania SWAT and federal agents raided the home. And during the raid, they found Mr. Kohberger's vehicle in the garage, seized, and later searched it. First thing we got to sort out is which law is going to apply. Same issue. Pennsylvania law enforcement violated Mr. Kohberger's Fourth Amendment rights by entering and searching his vehicle without a valid warrant. Now, I'm a little bit confused. I mean, I guess I'm not. They had a warrant, obviously. They had a warrant, but here we have, our first mention, there it is explicitly. The curtilage, it's there. It's there. I knew there would be a curtilage issue. Didn't anticipate this particular one, though. Parent's vehicle was in the garage, in a home where he was an overnight guest. This is an important issue for standing, right? Because the area that is protected in the curtilage is the residence. And so if it's not your residence, there can potentially be standing issues there. But protection, Supreme Court protection, has extended the privacy right of the home to the guests that stay overnight inside it. That applies to him, so he gets to rely on his parents' privacy expectation in their own home. So his car was in the curtilage. They needed a valid warrant. And for there to be a valid warrant, basic general requirements, there's got to be an affidavit. Oh, and by the way, Frank's. It's a Frank's argument. The argument here is that they wouldn't have been able to search the car without the warrant. And because the warrant itself is tainted because of Frank's and because of the IGG, the same things, than the AT&T account and the other warrant that they're also challenging, that for those reasons, had that improper information been excised from the Pennsylvania warrant, then they wouldn't be able to rely on it. They wouldn't have probable cause to issue the warrant and then to do the search. So That's the gist of the problem with that particular motion. But curtilage, there it was. They finally said it. I feel so validated. And now we have our last one here, the redacted search warrant. Here it is, the one for the parent's home itself and statements made after his arrest. So this one just has a few additional facts. So we know, once again, we got that search warrant December 29th, search warrant for the parent's home. So that in and of itself seems to validate the arrest of Mr. Kohberger on the out-of-state warrant on that previous challenge that was raised. So now we're going to go into some of the other details here, the details supporting the warrant. We already kind of know this stuff, went through this in one of the earlier motions. But now we have this last additional piece. Pennsylvania agents seized garbage at Mr. Kohberger's parents' residence and found DNA it determined was likely the father of the suspect, DNA found on the sheath. So that is the one additional piece of information that is included to support the search of the parents' home. We already know they did the search in the middle of the night. They broke the door, shattered the sliding glass door of the basement, held the entire family at gunpoint, and seized Mr. Kohberger, as they will do, and then these statements that we've heard about before. At 4 o'clock Eastern on December 30th, Pennsylvania State Police filed a criminal complaint against Mr. Kohberger. Now, I don't recall them filing a criminal complaint unless they're referring to the extradition complaint. So I'm assuming that's what they're referring to, because I don't recall him being charged with like some kind of crime arising out of his arrest. Conflict of law problem. Already discussed whose law is going to apply. Standing. Here we have the standing question raised. So again, he's got to be able to show he has an expectation of privacy in his parents' home when it's not his home. But he grew up there. He was staying there for winter break as an overnight guest. He unquestionably has standing. And the U.S. Supreme Court clearly had a situation just like this in mind. For example, an adult daughter temporarily living in the home of her parents would have no legitimate expectation of privacy because her right to admit or exclude would be subject to her parents' veto. So basically, Ben already anticipated this precise situation. Kids staying at your parents' house overnight. Yep. So searching and seizing his parents' home without a valid local warrant. Now, of course, we know they already had a warrant, but that's where kind of all of this is coming back around and reinforcing itself, right? So if they didn't have a fugitive warrant and this particular warrant fails, then they didn't have any type of authority in Pennsylvania to execute the arrest warrant, the out-of-state arrest warrant. So the out-of-state warrant could not have given them the authority to enter the homes. Is well established, no extraterritorial effect. So they need permission under Pennsylvania law to justify the entry. They did not knock and announce. This is a new challenge. We didn't hear this one. Didn't hear this one in other motions. So this is the one that specifically authorized the entrance in the home. So they would be required to knock and announce. There's limited exceptions for when they don't have to do that. If they do knock and announce and the people are silent, if the police are virtually certain the occupants already know their purpose, that's not going to apply here. Police have reason to believe that an announcement prior to entry would imperil their safety. Ding, 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 ding. Here we have the officer safety exception that is going to be the reason why they will not be required to have knocked and announced. Or the police have reason to believe that evidence is about to be destroyed. Don't know. But they're just basically going to say, we suspect him of perpetrating a violent, homicide. He's dangerous. Weapon hasn't been recovered. He may be armed. Therefore, we had concern for our safety. So they go through some comparison of the Idaho and the Pennsylvania, knock and announce rules, but they're arguing there's no surveillance. He wasn't seen, or he'd been surveilled. There was no evidence of weapons. There was no reason to take him inside of the house because he took daily runs. Police, the evidence sought was not of the kind that giving him a chance to exit the residence would have imperiled. It's not like he's going to, swallow his bundle of drugs or something like that, or flush it down the toilet. They're trying to get his car and so on and so forth. So that is a pretty decent argument, but they don't get to the officer safety. They're just basically saying, well, he was never seen with any weapons. Yeah, well, but would they have necessarily known? Like, they're not looking through the walls of his house. If he's got a knife in his pocket or a gun in a, belt holster, and inside the waistband holster or shoulder holster, something like that, are they going to see? Are they going to see that and know that it's there? Don't know. You just don't know what's in the home. So they cite this drug case. And they basically said, in that particular case, they really didn't buy it. They didn't seek a no-knock warrant. They can see through the front windows. It's typical. And that just the fact that the police would be exposed as they walked up to the house doesn't allow them to not specifically ask for a no-knock warrant just because they're going in to seize a whole bunch of drugs. Then in this Chambers case that they rely on, they're saying factually there was no need to do a forcible entry. And that's kind of important here because that's the whole argument the defense is making. You've had him under constant surveillance. You knew what his habits were. You knew he was going to leave the next day to go for a run, and you could have just waited for that point. There's no showing for why you had to do it in the middle of the night in the home, and why you couldn't have arrested him on his run and thereby, address the threat, the danger that him being there imposed, and then go back and search the house. They have specific reason that the parents would be dangerous. You need to put that in your warrant. So in cases where this guy has a history, known to have handguns, so forth like that, they just basically found a case where it's kind of an extreme example of a really dangerous guy. And by contrast, Mr. Kohberger isn't like that. He has no criminal history, no reputation for violence, or even being a gun aficionado. So taking all the allegations in this case as true, there is still no explanation as to why a small army was required to capture Mr. Kohberger, and no explanation for why they would do all that without any body cams. If he's so dangerous, don't you think you'd want to capture it on camera? Don't you think any one of those 50 people or however many it was, just go ahead and turn that on? But no, they didn't do that. They took the entire house by force. So it's not a terrible argument. It really isn't. But I think at the end of the day, they're just going to say it's officer safety, given the nature of the crime, serious crime, would make him a very dangerous person. He would have, the motivation to escape and so forth. They would justify the lack of knock and announce. Once again, Franks. Once again, IGG. Then we have this Miranda violation. So two alternative arguments for why statements that he made after his arrest, they argue should not be admissible. As soon as he was placed in zip ties and held at gunpoint without a Miranda warning, yeah, that's custodial. Okay. Talked about the requirements for Miranda. You have to be A custodial interrogation. Police are going to do that. They got to read you your Miranda warnings. When you are in zip ties and held at gunpoint, yes, you are in custody. I don't think that's going to be a question at all. So the issue is really going to be around interrogation. So they include this definition here. Not only express questioning, but also words or actions that the police should know are reasonably likely to elicit an incriminating response. So it's flexible. He was zip tied after a no-knock warrant was served. Okay, so now they're telling us it was a no-knock warrant. So the whole reason we went to that knock and announce is in case the warrant itself is bad. But if the warrant itself is bad, it wouldn't matter if they knocked and announced or not. I'm just kind of scratching my head with how all these pieces fit together. If it was a no-knock warrant, then I feel like we're done on that issue. Anyway. He was zip-tied at his hands and surrounded by police at gunpoint. Law enforcement did not Mirandize him immediately. Instead, they waited until after he was transported in a police car, handcuffed with at least 2 officers in the car. One was seated next to him in the back seat. A reasonable person in Mr. Kohberger's position would have understood himself to be in custody. Yes, he absolutely would. And this is fairly commonplace as well. If they don't immediately Mirandize you at the scene, then yes, they will often wait until they get you back to the jail or the police station or wherever it is that they have their interrogation room that they're going to put you in, where they have, the cameras up in the ceiling and the audio recording and so forth. 2 conversations took place before Mr. Kohberger was Mirandized at the police station. It is clear from the police station video that detectives asked him if he had ever been Mirandized before and said they needed to go through the formality of Mirandizing him. He said no. So I assume that means he said no, he has never been Mirandized before. But it's not clear if he said no, they don't need to go through the formality. No video or audio recording of the entry into the home and the initial arrest has been produced. Yep. That's right. No body cams, not a single one on any of those 50 or so people that got a no-knock warrant because of the danger of this entry. And video and audio began with Mr. Kohberger in the police car. So the real question here is the interrogation. The conduct of law enforcement with Mr. Kohberger in the house is referred to as small talk when he is being recorded during transport. So we don't know what he said in the house. We don't know what they said in the house, but we know that later on in the car, they characterize it as small talk. They say this can't be verified because no audio or video is produced. But that doesn't matter. The burden is always going to be on the defendant to show there's a constitutional problem with what happened here. And so the absence of verification isn't going to matter. If a law enforcement officer will get on the stand and say, we engaged in small talk at the home, that's all it's going to take. So the fact that it isn't verified is just not particularly helpful. It's going to come down to a he said, she said, if they want to further litigate this. What do the police officers that had these conversations, what do they say? And potentially, what does Mr. Kohberger say? The conduct of the officer in the police car during transport cannot be described as an interrogation. That seems like a big concession. However, without a video or audio recording of in-custody discussions inside the house, the true nature of the statements made in the car are without context. This is not a persuasive argument. It's just not. If you're saying they were taken out of context and there's additional context that would change the nature of that conversation, you have the burden to present what it is. And it may be that the only way that you can get that is from Mr. Kohberger. That's possible. Now, it is often the case in a motion to suppress that a defendant can testify for limited purposes of that motion and not have that be used in a subsequent trial. But it's just a rule-based protection. It's not like a constitutional level protection. So I don't know. I would have to check if Idaho has a rule like that. My guess is that they don't, because if they had protection for anything that he said in the context of a motion to suppress, then they could put his story forward by submitting an affidavit. Just write his version of events and have him sign it. And now you have some type of showing that would give this context. But without that, this is an extremely weak argument. It's really, honestly, I'm not even sure I would make it. I think they're covering their bases because of the timing of the Miranda. It's kind of like they sort of have to. But it's really weak. They're not meeting their burden. It's not the state's burden to record everything, even though, maybe it would have been better if they did, and maybe it's a little bit sus that at least with some of it they didn't. But the absence of it doesn't prove any particular fact other than it's just not there. So it doesn't help you. It doesn't help you establish anything with respect to the questioning that is not video recorded. So I don't think that one is likely to go anywhere. And given what we saw here about the no-knock warrant, once again, unless this stuff gets thrown out because of Franks or because of IGG, then I don't think we have an issue here. There's just not really anything else for them to go on. So that's all of them, guys. Way to go. Way to hang with me. That took a little bit of time, but we got through them. So the bottom line is, I think pretty clear. The strongest issue they have to work with is the overbreadth one. And in many respects, many of these arguments, I think they are quite strong. Some of them less so, just clearly the more that the law enforcement tailors what they're looking for, the less likely a challenge like that is going to work. But for all of your Apple data, all of your Google data, yeah, these things are inherently problematic. So those are strong issues, and I'm going to be very interested to see both how the state responds and how Judge Hippler analyzes that, how he reasons on that. These are significant, obviously, because these are the building blocks for the case against Bryan Kohberger. Now, as we know, anything that they've obtained from the time of his arrest has been subject to the gag order. So we don't know. We don't know what else is there. We don't know what all they have. But a lot of these warrants cover quite a lot of that information. And so if these warrants are flawed, from the inception, then they're going to have an issue. They're going to have an issue with the evidence they have going forward. And so a lot, I think, is going to hinge on the Franks. I put less on the IGG just because, like I said at the top, these challenges have not tended to be successful where they've been brought, like just inherently challenging the IGG. They're deeply problematic from a privacy standpoint because of the different type of genetic profiling involved. But within the legal framework that we have for analyzing your privacy interest in something like that, it's just really not a good argument for it unless it's his own DNA they found in the database, right? And if they broke the rules to get into that database, that could be a significant issue. So that's a big if on the IGG. The Franks, it's kind of a who knows. Kind of curious to see how that plays out with the Cy-Ray stuff. That implication that CSLI was not at all as it appeared. If that's the case, then yeah, the evidence against Mr. Kohberger is a house of cards that's built on those foundations. The initial arrest, the IGG targeted him in the first place. I think the likelihood of this case getting dismissed without a trial is low, but it's not zero. It's just going to depend. It's just going to depend on those details. If the police really did mess things up here, could be a problem. So hopefully when we get to that motion hearing, that's scheduled for January the 23rd. Hopefully we will hear a little bit more about the basis for this Frank's argument and what exactly they're arguing is the problem with the investigative genetic genealogy. So let's go ahead and go through your questions and comments now. Heather Hammond is a new member. Welcome, Heather. Marion, timeline suggests IGG via SNP was done first as claimed by the defense with STR attempted later, raising doubts. STR profiles are specific to CODIS. Yes, CODIS relies just on STR profiles. And this doesn't seem to be the timeline that we're getting now based on just how they've spelled it out, saying IGG is the root from which all of this grew. So if the IGG is flawed, then yeah, that's certainly a problem from a legal standpoint. But it also gives us a little bit of insight into the defense strategy that they're going to paint this as a targeted investigation. That it wasn't let's follow the evidence and see where it leads. It's we got Mr. Kohberger's DNA, trace DNA off of this knife sheath, and then based on that, we looked for evidence to corroborate reasons to suspect him of being the perpetrator. And then the question is going to become, how hard did you look? And then that's where we run into all these issues that came out at the motion to compel hearing about the video that they didn't go look for, and the other information they didn't seek out. Those are going to be issues. Buru berries doesn't need to be in a database. Dennis Rader, BTK's daughter's pap smear sample was seized and used as a DNA comparison. It doesn't have to be, but it does seem to be the pathway that was used in this particular case. That is interesting, though, and a little bit disturbing. Wasn't aware of that. Kathy, your realtor in Jersey, what can we do as a private citizen to keep our actions private? Is there any legal group working on this issue of data grabs? So the ACLU has been working on this. I don't know about other specific organizations that might be working on it. It would not surprise me if there are digital privacy organizations that are working on this type of information, or working on this type of legislation and advocacy and stuff. But it is a situation where, the best line of protection, first off, is always going to be, at least to start with, the legislature. It's not ideal because the legislature can change the laws, so it doesn't give you the kind of protection that, recognizing a right through the Constitution would give you. The problem is just that you can wait a long time for a court to get to a constitutional issue. And then, of course, there's no guarantee that they're going to decide it consistently with the principles they've articulated in the past. They can always say, well, the situation is different because reasons. And it just happens a lot. So for purposes of this type of advocacy, I think it's important to look at those groups that are promoting legislation that will help limit access to this type of information. Sarita Banana, I've missed our nightly chat so much. Happy to see y'all and Andrea. Not to be virtue signaling or anything, but has anyone been feeling a sense of deep sadness since Rick's conviction? Is there a way we can help? It has been a hard one. Yeah, I mean, you're not alone. You're not alone. In a way, I'm sort of calloused to injustice. I've spent far too much time in the trenches seeing, decisions that shouldn't have been made. I started reading this book. I read about it real recently on Twitter. I'm just going to get the name because I can't remember it quite off the top of my head. The name of the author, but I read about it recently on Twitter. It's called Duped, and it's by a PhD psychologist, Saul Kassin. That's his name. So he is one of the world's experts on false confessions, done a lot of research on them, how they work, cases where they have come about and so forth. I'm not very far into it yet, but it's just very alarming at how extensive a problem it is. It's one of those things that I think everybody, or at least most people, there's always going to be some people who are like, no, it never happens. I would never do it. Therefore, it never happens. But I think most people who are, reasonable people think, yeah, well, it might happen from time to time, but it probably just doesn't happen very often. This book is really making the case that it happens a lot. Like it happens a lot. Definitely way more than we would like to think. One of the examples that he gave, he goes like throughout history, this has been an issue. And sometimes it's people for reasons that maybe have to do with mental health. It's not even really clear. They just voluntarily step forward and implicate themselves in something that they didn't do. Sometimes it's what they call a compliant confession, where somebody is just sort of going along with what the police want you to say. They're trying to please the interrogator. And so they, parrot the story that the law enforcement gives them and says, yep, that's it. And the idea is that they're going to get some benefit out of doing that. Then the third type is what they call an internalized confession. And it's the one where the person becomes so disoriented and confused and basically separated from reality that they start to question, is it possible that I really did do this? And that can be associated with generating false memories of the event and things like that. So all three of these things have happened throughout history. One of the examples he gives is that during the Salem witch trials, there were 77 defendants that were prosecuted in 1 year, and 55 of them confessed. Pretty sure they weren't actually like casting spells and stuff on all of their neighbors, but more than 2/3 confessed. So I think it does happen a lot. As far as a way that you can help, I would suggest, if you haven't already, put your email address in at the rickallenjustice.com website. That's the one where they're going to be just kind of tracking people who are interested in supporting. We're still, in the early stages of what happens next. He's got to get sentenced. Once he's sentenced, he'll file for his appeal. Once he files his notice of appeal, he'll get his attorneys assigned. And then from that point is where things are likely to start to take action. So be on the list if you want to be in the loop of what may be opportunities to be able to help once that gets rolling. But I have, I'm not gonna say that it wasn't a lot to do all those nightly streams, and that it hasn't been kind of nice to not do them quite so often. But I definitely am glad to be back and wanted to have a chance to go over these motions. And I'm glad so many of you came and joined me for that. The crypto tax lawyer. As I'm sure AB recalls, lead investigator Brett Payne had almost no law enforcement experience. 2 years, came from the Army. Why do we put this guy in charge of high profile case? I guess it was his turn, or maybe he drew the short straw. There's a lot of ways that we could look at this. If they knew they were playing fast and loose, who's gonna be the fall guy? There's going to be a fall guy. If we know there's going to be a fall guy, I mean, just putting it out there. It's definitely one possibility. Maybe it was just his turn. It is a pretty good question. Why do you put the newbie in charge of everything? Lisa Lee Blue. I used to work in loss prevention. There were major changes in the laws in about 2015-ish, and now they cannot cuff, tackle, restrain, and more. That's interesting. do suspect that's probably state by state. Most states have either a shopkeeper's privilege or they do not, and that just basically deals with the right of the proprietor to use force, like to basically do citizen's arrest, to detain people for investigation or for arrest by law enforcement if they believe that the person has stolen stuff. So we do have a shopkeeper's privilege in Washington, and basically what it means is it gives you some immunity from assault. If you physically stop a person to detain them for investigation of theft, you're allowed to do that. And then if they fight back, well, they can get some pretty serious charges out of that. So it's not necessarily a safe situation as far as that goes, but this is typically an issue that's decided on a state-by-state basis. LB at Wakinian Taka brought up in chat how Gen AI could scrape all this data and build any based on a logic model for law enforcement. Yeah, exactly. I mean, once AI gets incorporated into all of these methods, we're done. When it's incorporated into the data harvesting and analysis, we're done. When it's harvested into, or when it's integrated with the DNA, mass DNA collection and analysis, like it's over. It's over. Like we have no privacy left at that point. Like the AI is going to have the potential to know what we're doing before we're doing it. Yeah, it's alarming. And the law is so extremely slow to respond to these types of situations that, I mean, look, we're barely still dealing with cell phones. We're not even in the universe of being ready to tackle AI, on any type of constitutional standpoint. And it's just likely that the technology, because of how it has accelerated, it's just going to be so far beyond everything by the point that it actually, like the beginning of it, gets into the courts. I don't know that the courts are going to be the place to keep this type of thing in line, to keep the Constitution protected. We may need to be depending on our legislatures for that type of thing. TB85, Andrea, after Trump's win, did you hear him say one of his 10 day one issue he's addressing was how warrants were being issued by judges, law enforcement? He's cracking down on how broad, etc. Good. He should. I mean, it's a great thing to, crack down on. It is a problem. I certainly understand why Trump would have personal grievances, with law enforcement investigations and warrants and stuff like that. Think, whatever you want of the merits of those, but if they go to solving a real problem, I'm all in favor of it. And yeah, the breadth of these warrants and the amount of information that judges will just rubber stamp law enforcement being able to go seize and riffle through, it's really alarming. It's really alarming. It's just very far beyond what I think the framers would have contemplated and tolerated if they could have even, imagined the amount of information that's now available on tiny little microchip inside an electronic device that we all have on our persons at all times. LB, would a company like 23andMe have standing to take the privacy issue to court, arguing they're damaged because if people are worried about privacy, they won't subscribe and they're losing business? If they can establish that, yeah, but that's always going to be the hurdle, is establishing your damages. How do you prove the counterfactual, the people that didn't sign up because they knew that the FBI was backdooring? It's probably a pretty limited number of people who even know that know that the FBI has these backdoors that they've been exploiting. And so then of those, how many of them are not using 23andMe, because of that? And then how do you distinguish that between people who aren't using 23andMe just because of general suspicion about having this type of information out there in the hands of a third party, saying we got to have some limit somewhere. So even though I would kind of like to know my APOE4 status, I'm not doing it. Just not doing it. Not where police could get a warrant and then know everything about the biological basis of my identity. They would know that. So, I mean, I think in theory there's a pathway, but just in practice, I'm not sure that it's likely to be real feasible. It would be nominal, I think, if you could even establish that there's meaningful damage there. Now, they can potentially go after the FBI for the FBI's own violations. If the FBI, for example, has got their own like terms of service that they have to follow when they're using these databases and they're violating those, then yeah, I think potentially they could. We might still run into an issue of damages, but that might be more of an issue where they could go for something like an injunction, get a court order saying you aren't allowed to do this anymore. You have to follow the limitations that the owner has put in place. That's possible. Lisa Shelton, Lowell, thank you so much for going over all of this with us. Well, thank you for joining us, Lisa. It was a little bit, we're back on the 4.5, 5 hour window horse. Just maybe was a little bit longer than I anticipated, but that's okay. I mean, it was a lot of motion, so it is what it is. All right, guys. Well, I hope that was helpful at giving you a little bit of a framework of what all of these things are about and, why it's so interesting to me from just a legal standpoint. And from that, why I'm irritated we don't get to read that IGG motion. I really want to read it. That's the one that's cutting edge. That's the one that's most just interesting from a novelty type of standpoint. So it's unfortunate that that's all sealed, but someday hopefully we will get to see it. And if nothing else, fingers crossed. Reminder that the argument on these motions is going to be on January the 23rd. So I will be planning to tune in for that. Now, I will warn you guys in advance, I don't think I'm going to be able to stream it. It's just going to depend on a variety of things, but the reason why is I'm going to be out of the country then. I'm going to be down in South America. And so I don't know how accessible I'm necessarily going to have a phone and Wi-Fi and things like that I would need to stream it. But what I do intend to do is watch it at the first chance that I get. And then at a bare minimum, what I will do is put something up on my Substack, whether that's like just a quick video I can film and upload, or some type of just written kind of reaction to it. That is probably going to be manageable. Just a question of timing when I will be in service and so forth to be able to do that. So we'll stay in the loop. No worries. But thank you all again for joining me. It is good to be back in the horse. Good to be back with my fish here, and appreciate once again, as always, all of your support. You mods, Jeff, over there in the chat, keeping the chat the awesome place that it is. Really do appreciate that. And thanks all for joining. I got no specific plans of something that I'm going to be covering here on YouTube in the immediate future. But if something comes up, if you've got the notifications on, just do that. I can be a little bit spontaneous sometimes about, what and when to stream and so forth. But otherwise, like I've been saying, keep an eye on my Substack. That's where I'm going to probably have most of my new updates. I'm still working on all kinds of follow-up stuff on Richard Allen. I still got side stories I'm working on, legal issues that I'm working on. I've also got some other things that I've been taking a look at that I want to follow up on as well. Specifically, I've been promising the Sandra Birchmore kind of where we're at with that in terms of the civil case. Take a look at the case against Matt Farwell as well, the criminal case. So just get us a little bit up to speed on those. I'm looking at some historical cases, which is a little bit of a different direction for my channel. I did the one historical video a while back that I really enjoyed because I got to do it with Professor Daniele Bolelli, who's my favorite podcaster ever from History on Fire. And so we did a joint presentation on the trial of Standing Bear, which is the most important civil rights case that you have never heard of. I just really enjoyed doing it. And even though it's not like, it's not the kind of video that gets a lot of, interest and traction and stuff like that, it's fun for me to make. And it's the type of thing that I enjoy. And if there's other people out there that enjoy it, that is good enough for me. So some of those things I have in the works as well. And otherwise, guys, I'm just going to kind of continue to get caught up here at home. I came home to a wet fall, a lot of leaves on the ground, still got some apples to harvest, got a lot of bonsai trees to put to bed. So got some things to do in the next several weeks. But like I said, keep an eye on the Substack because that's where my work in progress is going to emerge in the near future. So with that, guys, thank you everybody so much for joining me. Really appreciate you all being here. I'll look forward to seeing you guys all next time. Take care.